Morning.
I'd like to mention item number 3. I'm on behalf of Mr. J.K. Goswami, Standing Counsel of Veterinary Department.
Yes.
Actually, he has appointed newly. That's why, Lordship, I want some time for
Item number?
3.
You-
I have taken the other side consent.
Mr. Day, you are there?
Yes.
As prayed for by MS
D. Pathak.
B.
D.
D. Pathak, Learned Counsel, appearing on behalf of the newly appointed Standing Counsel, AHNV Department.
J.K. Goswami.
I, J.K. Goswami, Spencer, with consent from the Mr. R. Day, Learned Counsel, appearing for the petitioner, relist after
1 week.
a week on a date to be fixed by the registry of the school.
Highly bless.
With consent of the other parties. I beg to mention item number 5.
Item number 5.
Yes, the AK Purgasto is not keeping well. He has not also absent yesterday. So 1 week may.
Okay. As prayed for by Mr. M.J. Barua on the ground that the Learned Counsel, like Mr. A.K. Purkasta, Learned Counsel appearing for the petitioner, is indisposed to relist after 2 weeks on a date to be fixed by the registry.
Plus.
Lordship, with the consent of the petitioner, Lordship, I beg to mention item number 2, Lordship. Lordship, kindly adjourn for the day, Lordship. Kindly adjourn for the day, Lordship. My senior Ami Mahmood is unwell, Lordship. He is in hospital.
So change of weather, I think. Hospital.
Yes, Lordship.
As prayed for on, you have taken consent?
Lordship, I am for the petitioner.
As prayed for by Mr.
Yes, Islam on behalf of Ami.
Mr. S. Islam, Learned Counsel, appearing on behalf of Mr. M.U. Ahmed.
Ami Mahmood, Lordship.
M.U. Mahmood, Learned Counsel, appearing for respondent number 6 on the ground that so-and-so is hospitalized with consent from Mr. S.A. Hussain, Learned Counsel, appearing for the petitioner, relist after 3 weeks on a date to be fixed by the registry.
Lordship, they file additional affidavit, Lordship. We will file reply, Lordship.
It is submitted, it is further submitted that since an additional affidavit in the meantime has been filed on behalf of the petitioner, the respondent number 6 shall accordingly file return thereof, reply thereof. Yes.
Or addition, agenda for what?
Yes, Mr. Mohanta. Yes, yes.
In this matter, on last day, Lordship directed us to furnish instruction. Lordship, so yesterday I received one letter and they are praying for some additional time, Lordship, 4 weeks time, as they are processing on the order passed by the earlier Lordship, vacating the interim order. One interim order was there, wherein 24 posts were kept
Vacant.
not to fill up those posts. In the meantime, Lordship, that order has been vacated. And pursuant to that, Lordship directed me to obtain instruction. And they are saying that they are processing that order, Lordship. And
So what is to be done?
Was it vacated?
they are praying for 4 weeks time, Lordship,
For
furnishing the instruction as directed by your Lordship on 16/9/2025.
all right, let them have it.
Well, they may have, but the question is, that was vacated long back and they know this case is pending.
But you see, Mr. Mohanta, on the last occasion, the matter was heard and the judicial order is there whereby they were asked to obtain these instructions. So let them have it. We will not give them the so much time which they is asking.
Yes.
We may give them a shorter time.
Time, right?
But Mr.
And
Nayak,
let them
you
be
have the
specific. Let them be
you have the
Let
instruction.
me inform my senior colleague, Lordship, if a decision is taken, a positive decision, Lordship, then this petition will become infructuous and the petitioner will get the benefit.
Very well, you take your Mr. Nayak. I'm not
take the
saying
call.
you don't take a call
No.
or you don't do it. I'm saying you do it, but do it little expeditiously,
Really.
so that you see the sentiments of all the parties are also
No.
kept in mind. Ultimately, the matter is pending since 22.
22.
Correct,
Yes.
Mr. Nayak? We are in 25 now, almost in the end of 25.
After 3 weeks, then, Lord.
Yes. As heard Mr. K. M. Mohanto, Learned Senior Counsel, assisted by Mr.
K, my lord.
Huh? K. Sinha, Learned Counsel for the petitioner. Also heard Mr. P. Nayak, Learned Additional Advocate General, Mr. P. Datta, Learned Standing Counsel, APSC, and yes, Mr. P. Sharma. MP Sharma, Learned Counsel for the respondent number 6. Mr. Nayak, so and so seeks for the 2 weeks time.
It will take some time, Lord.
3 weeks time to obtain to place the instruction as called earlier by the order dated 16/9/2025. Relist, give a specific date. Relist on such and such date.
On. 25 Lord.
25,
If
Mr.
you-
Mohanta.
The only thing while you expecting that he will come on that day.
It is hope. Should I add that?
Yes.
তুমি মোক এবাৰ কৈছিলা যে এইটো ইনভাৰ্ট হয়
It may be noted that Mr. P. Nayak so and so is positive, is hopeful for a positive response in the matter from the
That is not.
state
required, I
government.
said.
Yes.
That is not.
Nilikhi.
তুমি নেগেটিভ হ'ব বুলি নালাগে
Okay.
Applies that. Applies. Item 4.
Yes, Mr. Kotoki.
The matter related to suspension, my lord, last occasion, my lord, was our concern, the review meeting, my lord, whether that has been
Reviewed.
there.
Yes, Lordship. Lordship, in fact, we have filed one document, Lordship. This was in the envelope. Come on. Side. On last occasion, we produced before this court, Lordship. The only point whether there is proper recommendation for review of the suspension, Lordship. Proper review was done for extension of the suspension.
Review otherwise was done
Yes,
within the period.
yes, Lordship.
Review was when on.
On several occasions, my lord.
No, Mr. Kotoki.
Yes, ma'am.
31/10/22 is the date on which suspended.
Yes, ma'am.
Suspension, na?
Yes, ma'am. That's,
Then 3 months expires when?
they have given it one, this chart, my lord, where the extension order has been given.
Where is the chart? I am just, no, I had a note written in the, so as per my notes, I have these dates. So just, can you indicate? 3
Actually-
months expired when?
3 months, actually what happened, there was the extension order on various occasions.
Correct. I think 3/4/23, the
It
show
starts-
cause notice.
Yes, no, section or the your lordship will kindly. your
Where
lordship
is chart? The chart is
Chart.
not here.
I can give the chart, ma'am.
Lordship,
Chart is given there, well.
it is already there. I can give. you
Where?
a copy. This is in the envelope.
Envelope,
Yes,
it's inside the envelope.
Inside the envelope,
The
Lordship.
chart.
Yes, Lordship.
Actually, the envelope is sealed, so I'm not
Oh.
opening it right now
No,
because
Lordship, it
if
was
I-
not sealed, I think on last occasion.
Yes, I'll open it if need be, but
The same thing is inside there.
look, these are extension. I just wanted for my understanding.
Yes, madam.
The 31/10/22 expire, this 90 days expires when?
The 90 days, before 90 days, they have used the extension order.
So that is a admitted fact.
That is
And
compliant.
thereafter, timely, it has been extended. These
Yes,
are,
Lordship.
Yes.
now you are saying that the review is mechanical.
Mechanical, madam.
This is your ground.
Yes, basically, same language they have issued, madam. The gravity of the offense and considering in a public interest.
Where is the first review
Cause review the affidavit, your lordship will find.
page?
Page
This is dated
Page 49, madam.
20.
Page 49. But it is still going on, Ms. Bhattacharjee.
Yes, Lordship, this inquiry is in the end stage, Lordship. I don't have the updated instruction because last date was on
I
22nd,
think
Lordship.
get the up-to-date
No,
instruction
Lordship.
because
Lordship may fix it on
I
Monday.
am not very inclined to allow this review business to go on for an indefinite
Yes,
period
Lordship.
because that defies the entire logic.
He is retired.
That defies the entire logic. You see, the suspension is only for a limited duration. That is why that 90 days period. And of course, keeping in mind that yes, for certain XYZ reasons, you may not be able to complete the disciplinary proceeding
Yes,
within that
Lordship,
period.
reasons are there.
Correct. That is why this is given. You see.
Reasons are there,
But
Lordship.
Ms. Bhattacharjee, that
Yes.
doesn't mean for last 3-4
Yes,
years,
Lordship.
you carry on
Yes,
doing
Lordship.
review and review after review
Yes,
a-
Lordship, I
and
agree.
do not complete. That would wholly defy the entire concept. It will amount to a suspension. That suspension in the end of the day would amount to a punishment, in other words. You
Yes,
see, I am only for academic
Yes,
reason I'm
Lordship.
saying, Ms. Bhattacharjee.
Yes.
Nothing on the merit of this
Yes,
case or
Lordship.
anything.
Only
You
one
see,
point just
so
I.
therefore, before going, I think to be fair, let me post it on another date.
Yes,
You get
Lordship.
the up-to-date status, or it is what
Of
stage?
the inquiry.
And then depending on the answer that is coming forth on that date, this court will take a call.
Yes,
Because
Lordship.
I don't think otherwise.
I just want to just appraise your lordship. Just 16/9/2024. This is because of the petitioner, because he has not submitted his assets and liabilities till lordship May 2025 lordship.
Assets not given
Yes,
till
lordship,
May
by the
when?
petitioner himself.
Till May when?
16/9/2024, he was asked to submit his assets and
But,
liabilities,
but
lordship.
so-called is,
Wait, that's on merit. I'm
Yes,
not on
Lordship.
merit right now.
so-called is regarding.
All right. Heard Mr. P. Kodokil, learned counsel appearing on behalf of the petitioner. Also heard Ms. M. Bhattacharjee, learned additional senior government advocate for the state respondent. Since the core issue involved in the instant writ proceeding is the pendency of the suspension order dated 31/10/22 till date, let up-to-date status as regards the let up-to-date instruction as regards the status of the pending disciplinary proceeding be placed on the next date. Relist on such and such date.
First week of November, madam.
First week of November is Ms. Bhattacharjee?
Yes, lordship.
Okay.
7th lordship.
Okay.
Because he's retiring in February, madam, that's why.
Lordship
All right.
on 7th. Deeply obliged, lordship.
Item number 6.
Yes, Mr. Majumdar.
Lordship, in this case. it is
Notice
number-
was issued, returns.
Give the instruction 2 days back only, so I need 4 weeks.
All
to
right.
file.
Heard Mr. L.R. Majumdar, learned counsel for the petitioner. Also heard MSB Sharma, learned CGC, appearing for the respondent. MS so-and-so submits that since instructions have been received 2 days back, for the a reasonable accommodation may be allowed in order to place the return. Prayer is allowed, relist after 3 weeks on a date to be fixed by the registry.
Lordship, date may fix, Lordship, in this case.
Yes,
it is,
yes, next.
Public.
Yes,
Lordship,
notice,
the
what about returns? You are appearing for all respondents, Mr. Gogoi?
B. Gogoi, my
B.
lord.
Gogoi.
Yes.
You are,
H. Purva, my lord.
Mahesh Parva. So, what about returns? Are you going to file?
My lord, this is a case of prolonged suspension, my lord, more than 90 days. my lord. I think it's a covered case, my lord, so, question of,
Yes, instructions?
on the last
My lord,
occasion.
we
yes.
have receipt of instructions, my lord. May I produce report is honorable?
What does your instructions say,
My lord,
please?
actually, they are seeking time for minimum 15 days, my lord.
For?
Uh-huh.
You don't even read the instruction and you want to simply pass it over to the court?
No, my lord.
Then, what is your instruction?
My lord, an FIR was lodged against the petitioner, my lord, under section of the Prevention of Corruption Act, on 12/2/2025, my lord. There was a criminal.
So,
And that's why,
so,
in order to review this matter, my lord.
257
please
days.
come up with some proper instruction, and I think you get your instruction or the affidavit by 2 weeks, failing which the matter will proceed in accordance with law.
May I pray, my lord, 257 days. I'm facing hardship, my lord. It is
90 days is over
90
already.
days is over, my lord. On 17/5/25, I mean, I've been giving
Has there been a review?
no reviews there till date, no review, my.
My lord, actually, Mr. B. Gogoi was.
No, we are not concerned with that. You are S.
R.A. Chaudhary, your lordship.
R.A. Chaudhary. Heard Mr. R.A. Chaudhary, learned counsel for the petitioner. Also heard Mr. H. Parwa, learned counsel appearing on behalf of Mr. B. Gogoi, learned standing counsel, finance and taxation. Mr. H. Parwa, no, it appears that the grievance canvassed by the writ petitioner in the instant writ petition under Article 226 of the Constitution of India is the continuous suspension of the petitioner without payment of subsistence allowance and review. Stop. Mr. R.A. Chaudhary, learned counsel for the petitioner, submits that since issuance of suspension order, how many days have elapsed? Almost, huh? 200? 57 days have lapsed. However, till date, no review or extension has been done. Today, the matter was posted to enable the respondent authorities to provide necessary instructions. However, Mr. H. Barua submits on instruction that, yes, what?
My lord, the instruction, my lord, we have received, my lord, that the petitioner has been granted all admissible benefits under law, including.
No, what about review? Has received some instructions. However, as regards whether there has been review and or extension during the currency of the period of suspension, no, the same is silent. Let specific instruction as regards whether there has been any extension of the suspension during the currency of the validity period as prescribed in Ajit Chaudhary so and so Supra, my citation to Geneva, comma, date, when?
In 2 weeks, my lord.
No, 2 weeks. You don't need that for 2 weeks. Next week. Give a date next week. Get that information.
Obliged, my lord.
After 7 days, yeah, next 7 or
Obliged, my lord.
Deeply affected.
Supplementary is item number 20.
Yes, Mr. Mohanto.
May please. The matter was regarding criminal proceeding or department proceeding may be going simultaneously.
Simultaneously, yes, who's fine, who's other side?
Lordship, I am appearing for the.
Return.
Lordship.
Lordship,
Yes, Lordship, we had, on last occasion only, we have, been served with copies, Lordship.
Do you want time?
Yes, Lordship.
Lordship,
few weeks
may I
time.
submit Lordship?
Yeah,
Lordship,
you
no,
have
no,
given them the copy only on the last occasion. She's
Yes,
entitled to
No,
file
no,
a
Lordship.
return.
I am not paying Lordship to dispose the matter. Lordship, what happened, Lordship? The similar kind of letter, more than 30 matters has been court has decided to hear the matter together, Lordship. That has been pending. My prayer is to list with the matter. We did same direction.
It is not similar, Lordship. The
Similar,
judge-
I
the
can see,
Lordship-
Lordship.
All right, I am not into all that. Let the return first come. If it is
Yes,
similar, you make that
Lordship,
later.
today is for
Heard
city
Mr.
matter.
D. Mohanta, Learned Counsel for the petitioner. Also heard Ms. M. Bhattacharya, Learned Additional Senior Government Advocate Assam for the respondents. MS Bhattacharya submits that extra copies of the writ petition has only been furnished when?
On last occasion, Lordship, on,
Because last occasion it was not given to you.
yes, Lordship, on 17th or 18th, Lordship, it was. served to me.
After posting of the matter on
Yes, sir.
after about 2-3 days since the last posting, i 15/10/2025, despite notice having been issued way back on 8/9/2025, she accordingly seeks she accordingly seeks how much time?
Lordship, 3 weeks time.
She accordingly seeks 3 weeks time for filing return in the matter. Prayer is allowed. List, when are those matters listed?
Lordship,
Just give me the date.
Lordship, today this matter are listing in the.
All right, list after 3 weeks of the date.
Lordship, they are-
List on list after 3 weeks. Did on such and such date. Relist on such and such date. Before the other court, you may get it. Get this matter fixed with that. We don't know what are those matters.
No, Lordship.
Yes,
I can
next.
select. Lordship, they are considered.
Mr. Mohanto, you should, if you have some urgency, you should have given the extra copies
No,
on time.
Lordship, they are today interim order, Lordship. Lordship,
No,
kindly
I am
put
not giving any interim order. If
Lordship,
you
that
are
may be rejected.
insisting, I'll reject it because you have given the extra copies later. Yes, next matter.
For hearing item number 8.
This is one of those unfortunate cases. man.
Yes, Mr. Chaudhary. Salary.
Several issues. This matter was in fact heard at length and reserved, and I'm not
All
going
right. Anyway,
into further details, man. This has been pending since
12.
2012. The issue is, before I take your lordships through the papers, may I give a background of the case? But this matter arises out of that PSU,
Hmm?
Assam Agro Industries Development Corporation. Your Lordship would be aware, this was one of the most successful PSUs in the state of Assam. It was started way back in the 60s. And the whole idea was, the policy of the government was, I'll take your Lordship through those papers. The policy of the government was that all the agricultural inputs throughout the state of Assam will be procured through this organization, this PSU. And the profits generated would be able to sustain the organization. It was doing wonderfully well. Over a period of time, the government started deviating from its own policy. It started awarding contracts to private parties. That is when many of the employees approached this on, in fact, there was a PIL file by two very prominent personalities. In the PIL, all these policies were taken note of, and this Honorable Court made an observation that that the policy would be adhered to. The government continued to flout. Some employees started getting together and they started questioning. They would float tenders inviting private parties, which was directly opposed to the policy. Again, the government came and gave an assurance that we'll stick to our policy. Again, they started flouting. Ultimately, a situation arose where it was felt that this PSU is no longer viable.
Right, okay.
It was decided to close it down. That is when the employees started agitating again. And
How many employees?
there were several, hundreds, about 300 odd, I think. Total of about 250.
200,
250.
250. And this petitioner, how many petitioners?
Petitioners are about 67.
67, about.
So when it was decided to close down, the government itself came up with a policy because there was a huge hue and cry. The government gave two options, that you can either opt for voluntary retirement, then you will get your package, retirement package, or else we will re-employ you in the line departments and your entire service
In
is-
the, re-employ you in the,
in, let's say, the agriculture department or other
in any other department of the government.
of the government, and all your service related issues would be taken care of. Now we are the people who opted for re-employment, absorption rather. The options were taken.
Ultimately you were re-employed. So then some terms of,
What happened was,
sorry, I am rushing you. No worries. You take your pace. Go with your pace. I just,
Yes.
sometime I have this
I
tendency of
appreciate it.
posing a question. No, don't take it
Absolutely.
otherwise.
Absolutely.
Yes.
so they, although the options were taken and the policy was declared, they refused to absorb us. That's when we had to approach this
Oh, they refuse to absorb.
refused to absorb. Ultimately, we had to file a writ petition. And in fact, that's a very, very elaborate judgment. All these facts that I am narrating are recorded in this judgment. I'll place the judgment. Ultimately,
Just indicate the page for the moment.
the judgment starts at page 35. It's a very long judgment.
No problem.
Honorable Justice
No
Amitabh Roy's
problem. I
judgment.
just wanted to note down that page. Yes,
All these facts are recorded, madam.
very well.
In the judgment, the policy of the government to absorb and that all their service related issues would be taken care of is expressly recorded. Based on that, this Honorable Court directed our absorption forthwith, and also a direction that our issues pertaining to the arrears of salary, because we were left high and dry. Since it was a policy of the government to absorb us, even the arrears we would have been entitled to. I mean, this is a period for which we were not allowed to work. This matter was taken up to the division bench. Division bench rejected the state's appeal. And
That is at page.
that is at page 71.
Yes.
Even thereafter, they refused to comply. Ultimately, we had to file a contempt. And the Honorable Single Judge's judgment is of 4th of December 2007. Ultimately, we get absorbed.
The contempt order is also here.
Contempt order is not here,
Okay, okay. No problem.
but we have made a statement.
No problem. Yes.
Ultimately, we were absorbed on 21/3/2011.
21/3.
2011. Yes. So the closure of the PSU was, your Lordship may perhaps like to take
Yes, yes.
that date also.
Yes, please.
The closure, decision to close it down, cabinet approval date is 22/8/2006.
Yes.
And the notification of closure of the PSU is dated 26/9/2006.
26/9/6. Dekha to me.
Ah. After 5 long years, after several directions being issued, we get absorbed in 2011. And now what they do is, that is what we are against. When they absorb us in 2011, they wipe out our entire past service. And since we were treated to be fresh employees, all these employees, many were on the verge of retirement.
Overaged.
No, we were otherwise absorbed in terms of the policy. But
At the
Let's-
fag end of your.
if a person is 58 years old, they put us under the new pension scheme, there would be hardly any contribution because it's a contributory pension. Now, all our earned leave that we had earned in our past service, that gets wiped out. So the salary in lieu of earned leave, which any other government employee would be entitled to, that gets wiped out. Our gratuity gets wiped out. Our seniority, we are not even claiming at this stage because many have in the meantime retired. Some have in fact also died. So that is how the matter is before your Lordship. We are claiming there are 5 claims. Since we were treated as fresh appointees, the pay fixation was at the entry level. And your Lordship is aware, under FR 22, pay fixation when you are absorbed, pay fixation has to be as per the last pay scale wrong. That is our first claim. The second claim is, we were otherwise would have been entitled to pension in terms of the pension rules of 1969. Now, since we were treated as fresh appointees,
New pension rules.
new pension scheme, and there was hardly any time left for any contribution to that pension. So we would not get anything in the name of pension. The third claim is gratuity, which we are otherwise entitled under Rule 135 of the pension rules, 135(1) and 135(3). Then the fourth claim is the salary in lieu of earned leave, which in terms of the latest notification, it is equivalent to 240 days, which we would have been entitled to. And obviously, the decision to close down was taken way back in 2006. We were illegally deprived from rendering our service. So therefore, with effect from the date of closure, arrears of salary. So these are the 5-fold prayers in the writ petition. Now may I place, Ballot, the facts. The facts would be clear from the judgment itself. They are
Yes.
not
35.
page 35 it starts. If your Lordship so desires, I can, the entire facts have been narrated elaborately. Your Lordship
Yes.
knows,
Yes, yes.
my Lord Justice Roy.
Yes, we are all acquainted. Yes.
If your Lordship will kindly turn to page 41,
Yes, I have page 41.
para 3 onwards.
Yes.
To comprehend appropriately the rival stands of the parties, it is unavoidably necessary to traverse their pleading. With the development of agriculture in the progressive lines in the state of Assam, demand for seeds, fertilizers, pesticides, and other infrastructural inputs increased, which necessitated the installation of a suitable procurement and distribution system with a network percolating to the grassroots level so as to facilitate availability thereof to the farmers in time. The AIDC being conceived of to cater to these exigencies was incorporated and registered as a government company on 27/1/1967 under the Companies Act so and so. At the time of its incorporation, there were two shareholders of AIDC, namely the Director of Agriculture Assam and the Governor of Assam, represented by the Secretary to the Government of Assam Department of Agriculture. The Government of India having decided to come to the fold, the President of India acquired 50% share in the corporation. Resultantly, the said paid-up capital of the corporation was 2.2 crores, held in equal shares by the union and the state governments. The management of the AIDC was vested in the board of directors appointed by the Government of Assam. Out of 12 such directors, including the managing director, 6 were state government officials, 3 were central government nominees, and the remaining 3 were non-official directors nominated from amongst the public. Over the years, the corporation developed a good infrastructure with efficient officers and trained employees in almost all the districts of the state of Assam for catering to the needs of agricultural development. The Department of Agriculture, Government of Assam, by its memo number so and so dated 7/3/77, made it mandatory for the Agriculture Department to procure all kinds of agricultural inputs required by it for implementation of the various government schemes through the corporation. The AIDC was made the sole procurement agency for all kinds of agricultural implements required by the Agriculture Department of the state. On being approved by the Finance Department of Assam, the government also allowed the corporation to charge a fixed margin on such inputs supplied to it for meeting its administrative expenses. It was clarified thereby that the Director of Agriculture or its nominee would venture to make purchases of the required articles through the Development Purchase Board only. The Director General, Bureau of Public Enterprises, and Additional Secretary to the Government of India, by the Office Memorandum dated 15/10/1980, issued certain directives with regard to purchase and price preference for products of public enterprises in competition with private sector undertakings in the matter of purchase by the government department. The said office memorandum provided in particular that the state government departments and public sector undertakings should invariably purchase their requirements from public enterprises wherever such undertakings were able to meet the demand. It was also disclosed that subject to the negotiation for an agreement on price preference of not exceeding 10% would be admissible to the public sector undertakings. The Secretary to the Government of Assam, Department of Agriculture, prepared a cabinet memorandum on 5/2/85 with regard to purchase and price preference for products manufactured or dealt in by the corporation, wherein while referring to the main objects of AIDC, the said authority certified its competence and credibility in supplying and servicing articles like fertilizers, insecticides, tractors, power tillers, fencing materials, tires and tubes, etc. It was emphasized that as the corporation's limited pursuits were not profitable enough, it was essential to make it viable by utilizing the facilities created to the fullest extent. One of the measures suggested was to ensure procurement of the requirements of the government departments and the public undertakings from AIDC. A proposal to grant price preference of 10% to the corporation in conformity with the office memorandum dated 15/10/80 was also mooted. The Finance Department as well as the Department of Public Enterprise also accorded their approval to the said proposal. Subsequent thereto, a cabinet decision was taken on the issue of purchase and price preference for products manufactured and dealt with by the corporation in competition with private sector enterprise organization, etc. In pursuance whereof, the Commissioner and Secretary to the Government of Assam, Department of Public Enterprise by OM being number so and so dated 16/5/85 issued certain guidelines which were required to be strictly adhered to by all government departments, their subordinate authorities, government organizations, and public sector undertakings for making their purchases of materials, products dealt in or manufactured by AIDC. The said authorities were directed to make their purchases of such items invariably from the corporation. And the list of materials, products dealt in by AIDC was also appended to the memorandum. Price preference not exceeding 10% was also made admissible to the corporation on all items, materials, products dealt with, supplied, or manufactured by it. In harmony with the aforesaid guidelines, the Director of Panchayat and Rural Development Department, Assam, by his communication under so and so dated so and so, instructed all Panchayat directors, etc. The petitioners have asserted that in spite of such an overwhelming consensus at different levels, mandating purchase of agricultural inputs by all government departments, organizations, and public sector undertakings exclusively through AIDC for inexplicable reasons. In particular, the Department of Agriculture and the Director of Panchayat and Rural Development resorted to purchases from various private parties, disregarding the corporation. Though the AIDC was a pioneer organization not only in the state but also in the country to have introduced power tillers in the state in the long past, contract for supply of some major agricultural devices such as power tillers were allotted to private parties bypassing the corporation. Interestingly, however, after the issuance of the work orders, tripartite agreements were entered into between the Director of Panchayat Rural Development, AIDC Limited, and the respective private parties favored with the work orders for various post-purchase supply measures to be adopted with the assistance and backup of the corporation. So, pausing here for a moment, what they started doing was they would award the contract to a private party. And once the contract is awarded, the responsibility is first on the corporation to ensure that it reaches the grassroots levels at in various districts, and for maintenance of these machineries, etc. They would still take the services of the corporation, but would award the contract to private parties. Through these agreements,
But how are these relevant, Mr. Chaudhary?
the reason I'm pointing out this is that it was entirely because of the apathy of the government that it faced closure. And it is in this
So
context that
that's how you are connecting their responsibility. But nonetheless, you see, ultimately this decision mandated that no, you cannot just get rid of these people. You must, if they have exercised,
Yes.
because first of all, you have come up with that policy
yes,
whereby you had given them an option.
yes,
Now, once you give that option, if they have chosen that option, then you must fulfill
absolutely.
your obligation under that policy because it's an estoppel. You can now go back and say, no, now I
fact-
have changed my mind. This is not how the
Your Lordship has absolutely hit the nail
government
on the head.
can work along. So therefore, the things will now boil down to what were the terms and condition or what was
Absolutely.
in the mind of the government at that time
Hmm.
when this option was given to you was because it goes automatically that the past service cannot just be wiped out.
Absolutely.
Right, because then it makes no sense. Because they, as you have said, and plus because of the lapse of so many years, they are already at the verge of retiring. Few of them, and
Many have retired.
Many have retired. So it is not going to give them any as such any benefit.
Absolutely. Absolutely. It is
Then
like
that's all. It's like what you are
No, but-
giving by the right hand, you are taking it back by the left hand.
absolutely. That is
You cannot do that.
in that case, my lord, I am skipping that whole portion.
No,
I will,
I am not going to, you can show me if something else otherwise, but
I-
this history perhaps is already taken care of,
Absolutely.
right? We can come to that policy thing.
policy, my lord. The policy portion is extracted.
In this
Mr. Lord.
judgment only, perhaps it's there.
In fact, your lordship may entirely skip up to page 63. Your lordship will come to page 63.
Page 63.
At the bottom of that page, the last paragraph.
Yes, revised policy.
The revised policy on voluntary retirement scheme for the employees of the state level public enterprises Assam was circulated by the aforementioned notification dated 15/2/2006. The benefits of the VRS package were in respect of all state level public enterprises. in
One
the-
second. Before going there, then I might just lose that chain. One second. The closure was around what time you said? Around 2006?
Yes.
Around 2006?
Pages are relevant, madam. The cabinet decision to close down is dated 22/8/2006.
22/8.
These facts are not disputed, madam.
No, just one second. Can we come back to page 46?
Yes, madam.
Paragraph 8 you have not placed, right?
Page 46. This is again going back into the history one.
Yes, but I don't think we have reached till para 8, isn't it?
No.
So let's start with para 8 for the time being, just to, because the other part I've understood.
Well,
That is not, we don't need to go into so much of that part. You see, what are their, let's start because I want to connect the dots.
Yes.
Otherwise, you see, I will have to read all this again.
In fact, my lord, what I have done is,
Huh.
I have also prepared a brief written argument.
Very well, very well.
That will,
Very good. But just let's
Yes.
just place para 8 onwards and we'll see where again we'll go back to 68 or whatever. But
Well,
just to get that.
certainly, certainly.
Yes, yes.
Para 8, ma'am. In the year 2001, a committee for fiscal reforms was constituted to conduct an in-depth study on the subject, which in its report emphasized that AIDC is one of the corporations which deserved and needed the government's immediate patronage and attention. It was underlined that these units were incurring loss and could be revitalized inter alia if the government dues were cleared and the purchases were compulsorily routed through them. The task force that was thereafter constituted by the government, notification being number so-and-so dated 23/2002, to work out an appropriate action plan to operationalize and reinvigorate the corporation, also in its meeting held on 11/6/2002, underscored the indispensability of guaranteeing purchase of the agricultural inputs by the government department, singularly through the AID. The Department of Public Enterprises, Government of Assam, in its meeting on state level so-and-so, held on so-and-so, also recommended the said step. The petitioners have contended that in spite of all herein above, the Department of Public Enterprises invited tenders from private parties for supply of various agricultural appliances in the month of February 2003. This move was assailed by the Assam Krishi Udyog Karmachari Sangha and others in WPC number so-and-so. Whereafter, by order dated so-and-so, this court stayed the process. Subsequent thereto, in a meeting attended by the Deputy Commissioners, top functionaries in the Government of Assam in the Agriculture Department, Director of Agriculture Assam, the Managing Director of AIDC, and the office bearers of the Employees Union, an unambiguous assurance was extended for purchase of equipments, machineries, fertilizers, pesticides, micronutrients, etc., under various schemes to AIDC, apart from prompt liquidation of outstanding amounts. Acting on the minutes of the said meeting, the writ petition was closed on 8/4/2003. As the stalemate lingered, resulting amongst others in non-payment of arrear salaries due to the employees and the workers of the corporation beyond their endurance, they, along with the employees of other PSUs, constituted a body nomenclatured Committee for Struggle to Revive Public Sector Undertakings, which approached this court with PIL number so-and-so inter alia for obligating the government to take steps with regard to the sick public sector undertakings by formulating a time-bound scheme and also to release the long-pending arrear salaries due to their employees and workers. This court, by order dated so-and-so, 14/9/2004, directed the state respondents to submit an interim report highlighting the steps taken in this regard and the progress made. It also recorded the commitments made by the Chief Secretary to the Government of Assam and the Commissioner and Secretary to the Government of Assam Public Enterprise Department with regard to the initiatives proposed to be taken for redressal on the grievances of petitioners. Confirmed assurances were also offered that all possible measures and steps were being taken by the government to identify the public sector undertakings for closure, disengagement, revival, as the case may be. In the meeting that followed on 23/8/2004, participated by all heads of departments as well as managing directors of the respective public sector undertakings, a chart was drawn up to indicate the public sector undertakings identified for revival, with the corporation topping the list. The petitioners have alleged that, slighting the above commitment, the Chief Engineer Agriculture Department on 11/2/2005 issued a supply order in favor of a private party for purchase of so-and-so Shakti Power Tiller, and that too without inviting tenders. According to the petitioners, in this transaction, an amount of 15 lakh so-and-so was paid in excess of the manufacturer's price, casting an avoidable burden on the state exchequer. Being thoroughly exasperated by the persistent fanciful departures from the professed policy of the government in utter disregard to the directions issued by this court in Assam Krishi Udyog Karmachari Sangha instituted so-and-so, was disposed of on so-and-so by this court, obligating the concerned departments to route their indents through the AIDC. In fact, thereafter, your lordship may skip this portion also, para 11 and 12. Para 12, there is one important sentence, my lord.
Yes.
The first sentence. In the parleys that followed between the Government of Assam and the Employees Association of the corporation, it was represented that the decision of closure or otherwise was a matter of policy, and that in no case the closure would be imposed at the cost of the employees. Your lordship will kindly mark these words. This was a commitment which has been judicially accepted.
Legitimate expectation starts.
Well, and thereafter, my lord, all the other intervening developments are recorded. And if your lordship will, till page 53,
I think no, it comes, the decision of closure. I think let's carry on with this this paragraph. So this is the date, isn't 22/8/2006? The decision for closure of area eventually received and approved of the cabinet on 22/8/2006.
precisely.
And consequently, so and so declared the corporation to be closed with effect from so and so.
Fine.
The notification after so and so to collect.
These
Who had not opted? So that, but where do we get that option thing?
that I am coming to.
Yes, yes.
That is what I was placing from page 63.
That comes there.
My,
Okay. Page 63. Yes.
so ultimately, all this kept on transpiring. And then comes the policy on this option.
Yes.
That last paragraph.
Yes.
In fact, in that page, from page 63, how the whole thing happened.
Yes.
In fact, my lord, if I may place from the top of the page. itself.
Yes, yes. Subsequent thereto.
Subsequent thereto, the Principal Secretary to the Government of Assam Public Enterprises Department was requested to move the cabinet for approval of the closure of the corporation. The letter dated 28/12/2005 issued by the Secretary Agriculture Department to the said effect disclosed that the proposal for closure had the approval of the Minister of State, Agriculture and the Chief Minister of the state. By the notification dated 26/9/2006 issued by the Principal Secretary to the Government of Assam Agriculture Department, AIDC was declared to be closed with effect from 31/8/2006. As the said notification discloses, it was preceded by the cabinet approval of the said proposal sanctioned on 22/8/2006. By the said notification, however, the managing director of the corporation was requested to furnish the list of employees who had not opted for VRS by indicating their designation, educational qualification, date of birth, superannuation, and entry in service, as well as the scale of pay. This was for the purpose of absorption. A representation on behalf of the Employees Association of the corporation was submitted on 30/10/2006 before the Additional Chief Secretary to the Government of Assam, Director of Agriculture, and beseeching the state authority to absorb the non-VRS opting employees in terms of the notification dated 26/9/2006 and the voluntary retirement scheme circulated by the government notification number so and so dated 15/2/2006. Early release of the arrears was also appealed for. Their entries, however, remained unresponded. The revised policy on voluntary retirement scheme for the employees of the state level public enterprises was circulated by the aforementioned notification dated 15/2/2006. The benefits of the VRS package were in respect of all state level public enterprises in the state, irrespective of whether those were to be closed or revived or could afford to discharge the dues of their employees from their own resource generation. Clause 9, this is the relevant clause. Clause 9 thereof, having a definitive bearing on the present adjudicatory process, deserves to be extracted. A section of the employees of some SLPEs who may be absorbed in the state government departments will not be entitled to the VRS package. However, for the period of service rendered by such employees in the SLP prior to absorption in the government department, he/she will be paid the arrear, salary, wages, etc. They will not be eligible for any other component of VRS package, as their problem of post-SLP service rehabilitation will be fully mitigated by employment in government departments. This is the policy. They will not be entitled to any VRS package merely because all their issues will be taken care of by way of absorption. And based on this promise, this Honorable Court ultimately, in fact, this is again recorded at para 31, first sentence itself. Clause 9 is categorical to the said effect, which clarifies that they would not be eligible for any other component of the VRS package, as their problem of post-SLP service of rehabilitation would be fully mitigated by their employment in government department. This is judicially recognized, and this has the approval of the government, approval of the Chief Minister, everything. Ultimately, my lord, the direction issued is at page 69. In fact, at paragraph 40, this Honorable Court also took note of a Supreme Court judgment, which the Kapila Hingorani's case, to note that it is the responsibility of the government ultimately when it comes to public sector undertakings. Para 42 mal, is the operative code
Yes.
at page 69. In the above factual premise and in face of the determination made herein, this court is persuaded to hold that the petitioners are entitled to be considered for absorption against the vacant posts enumerated in the list appended to the aforementioned letter dated 2/6/2007. And if I may pause here for a moment, why our reference is made to this is we had also brought on record that there were more than sufficient vacant posts available in the agriculture department, but in spite of that, we are not being absorbed. That is why reference to this.
With that letter 267.
2/6/2007. In terms of the representation promise made by the state respondents for their redeployment, re-employment, following the closure of the corporation and affirmed by the cabinet in its decision so and so, ordered accordingly. So far as absorption is concerned, it is taken care of. As the petitioners weighed in bona fide expectation and understandably that with the sudden turn of events, they have been left high and dry with their families. The process as directed should be completed within a period of 6 weeks from the date of receipt of the certified copy of this order. And thereafter, para 43. Needless to say, the state respondents would also attend to their claim for area salary and allowances due to them before the closure and following the quantification thereof, defray the same to them.
So this has given.
But in spite of that, it has not been given.
Needless to say, the
Yes.
state respondent would also attend to their claim for area salary, would also attend to their claim.
The
For-
fact that this
A
honorable body
little bit of handle,
attend to
handle.
they have taken advantage of that. And
No, in that case, they have to be reasonably come up with something to deny because they cannot just not give.
exactly.
Because it says would also attend to their claim for area salary allowance due to them before the closure and following the quantification thereof.
Even before
Defray the
closure,
same to them forthwith.
in fact, my lord, not only before, is it, now here is the situation, what had happened was, 2006, they closed down. So if even prior to closure, for about 2-3 years, they had not paid our salary. So here was a case, we had come at the stage of the closure. So that was for services rendered. Now here is a situation that you are illegally denying me. Till 2011, in spite of a direction of this court, till 2011, we were
So
not even absorbed.
post that contempt, they absorbed you. Post contempt, they absorbed.
Once we filed the contempt,
They absorbed, correct? Now, the moment they absorbed, they did not give you these.
they treated us like
Right.
fresh appointments.
Now, where do we get that?
I'll come to that. What they did was this, madam.
Because that is totally, and that is under challenge here, right? That
We have not,
subsequent absorption,
we could not have challenged the absorption.
correct? But denial.
Denial.
So that you must have given a representation,
Yes, sir.
and that is your case here. That representation. I mean,
Was not attended.
but,
My lord will-
just 1 second. Who's appearing for the government? You are there.
AG, Mr. P. Nayak will be addressing.
Where's
Mr.
Mr.
Arvind.
Nayak?
He's on legs in another court, Lordship. There is a problem. That's why, Lordship.
No, that is not a problem. You are here.
Lordship, my senior
But-
counsel may continue. Lordship,
Uh,
our part. we
But
can-
do you see, this para 43 of this judgment is loud and clear.
But when they were absorbed, Lordship, they had signed an undertaking in an affidavit that they'll abide to the terms and conditions of our policy, Lordship.
That's right. So that doesn't mean
And
that
after
that
they were absorbed, Lordship, they were government employees.
you see that does not change anything. That policy has been looked into by this court, the judgment which has attained finality. And as per that judgment, yes, you go with that policy, but needless to say, you shall not forthwith deny them those area things. You
Lordship,
will look
after
into those claims.
2006, Lordship, the corporation was closed.
Very well.
And they were absorbed in 2011. And they were government employees.
What about
from
the area salary
2011.
and allowances which were due to them? Have you given them before the
Lordship,
closure and following the
that was in the
quantification thereof?
corporation. The closure was in the corporation, Lordship. That we cannot say.
No, that has to be given. Who will give it? That corporation is a government corporation. It's an AIDC. It is not some private company. It's a government corporation.
Regarding the.
I think,
NLC
Mr. Chaudhary, that is also an issue, isn't it? That part, which
That-
part where you,
Entire thing, my lord, I will,
Yes,
what,
yes.
what,
Ms. Counsel, I am only indicating that these are the area you will have to, you have to respond.
Corporation lordship, that I don't think is the fear of the
Yes.
petitioner lordship.
Needless to say, the state respondent is also attend to their claim for area salary and allowances due to them before the closure and following the quantification thereof. Both. Have I understood it correctly, Mr. Chaudhary?
our prayer is like this, man. If your lordship comes to our prayer pertaining to salary at page 24. What we are claiming is, so this has been a long pending matter, my lord. My juniors have lost touch with the clients of.
Lordship,
Perhaps, my lord, till the date of closure, they ultimately ended up paying. What we are claiming in this is mandamus shall not be issued, first prayer, mandamus shall not be issued directing the respondents to give effect to the absorption of the petitioners from 26/9/2006 and to grant all consequential service benefits including area salaries with effect from such date. Because
Past services. Your benefits of the past service.
from the date of closure, because we were illegally denied absorption for a long period of 5 years. But let me place these documents, it will make the position clear. What my learned friend is pointing out is this, madam. If your lordship will kindly come to page 94. After the matter, in fact, my lord, the division bench judgment also,
All right, miss, you may take your seat.
my lord,
You are right in pointing that out otherwise. I stand corrected. I thought even that part was part of the claim. So,
prior
yes,
to closure is perhaps not, my lord, anymore.
yes, understood.
Page 71 is the division bench judgment.
Yes,
At page 93, the learned single judge judgment has been upheld.
90,
Page
Three.
93.
yes.
The appeal filed by the state was dismissed. And now what they do is this one. Page 94. This surreptitiously issue this document. And this is your lordship will note, this is a communication. At clause 8, your lordship will see the employees absorbed will be given pay by the Department of Agriculture only from the date of joining in the Department of Agriculture. They will not be entitled to any pay during the gap period, that is from the date of release by AIDC till the date of joining of the agriculture. And if your lordship will turn the page at clause 13, clauses 12 and 13. Their services after joining the government post will be governed by the existing rules and regulations applicable to the government servants. Next, 13. The petitioners or employees will have to give an undertaking in the stamped paper or in the form of an affidavit about acceptance of the offer and terms and conditions before joining the government post. Now, if your lordship kindly turns the page, your lordship will find that this is not even marked to the petitioners. They do it behind our back, and it is a communication between the Secretary Agriculture Department to the Director Agriculture Department. They take a decision behind our back, and then, and your lordship will kindly note, for years together we are going without salary. We are virtually on the streets. At such a juncture, this undertaking at page 102 is thrust on us. Virtually at gunpoint, we are told that we will absorb you only if you fill up this undertaking at page 102. Your lordship is aware of the law, Rajanath Ganguly, that there cannot be an unconscionable contract. We were at no bargaining position at that stage. My specific instruction is these employees had to take their children out of the schools and colleges because they could not pay the fees. They were literally on the streets. At that point, were we in a position to bargain with the mighty state? So we did, and that is, my learned friend is right to that extent. We did sign this undertaking. But what will be the value of that undertaking is one of the
Which undertaking is that? What page?
page 102.
Yes.
This is the format, and
That
it is
they
a-
have given you.
this. So
You
what
did not have the bargaining power.
we absolutely did not have the bargaining. Now, after this, we are ultimately, after we submit the undertaking, at page 104 is the order of absorption. Then we submit a representation on 21
So ultimately, the issue would be whether that undertaking can be said to be voluntary,
Exactly.
or whether it will stop you from now raising this claim. I
The-
think that becomes one of the most.
In fact, there are judgments of the Supreme Court. Following the judgments of the Supreme Court, our High Court judgments are also there. In fact, one judgment is a very leading judgment.
Saying?
Honorable Justice Rishikesh Roy, following Brajanath Ganguly, that
Saying?
if they are identical situation had happened in the education department, where a similar undertaking was thrust on them. And I had placed, in fact, I had the occasion to argue that case also. I had placed Brajanath Ganguly, saying that these people, they have been going without salary for years together. For them, they were not in a position, because they wanted, I mean, if they get absorbed, at least from next month, they can expect the current salary. So they were absolutely not in a bargaining position with the state. And that argument was accepted. This is a famous, Usha Rani Goswami. In fact, those two judgments I would be relying on. The value of the undertaking. Now, my lord, the prayers are like this. First,
You on water, Mr. Chaudhary?
I think, take it. My first submission is
Yes.
that in a situation like this, the past service cannot be wiped out. Let's take a hypothetical situation now. One Mr. A is taken on deputation from post Department X to Department Y. In the capacity of, assuming hypothetically,
Brojanath Ganguly too late hoga, huh?
they have given a list of dates, list of books. It's included in that.
Jijikhini Disa ase na Blackwood. Yes.
Now, one Mr. A, assuming he is an assistant engineer, he is taken on deputation from Department X to Department Y. Ultimately, after rendering services for a few years, Department Y decides that we would like to absorb him. Now, for him, it will be a fresh appointment in Department Y. Does he enter as a fresh entrant? Because his seniority, all the benefits, service benefits, that all the increments he had earned would be wiped out. It is for this reason that past service is required to be counted. And on that, my lord, the famous judgment of S.I. Ruplal, I would like to place at the very outset. 2001, if this proposition is accepted, all the other prayers made would follow as a matter of consequence. Here is exactly the situation that I had just given the example of.
1 second, he's. I said-
2000 volume 1 SCC 644.
Yes, paragraph.
Relevant paragraphs are 15 and 16.
15 and
60.
60. Past service.
Past service. This is directly on the point.
Yes.
As one,
Yes, please.
para 15. At page 65.
Yes, please.
We will now take up the question whether the appellants are entitled to count their service rendered by them as sub-inspectors in BSF for the purpose of their seniority after absorption as sub-inspectors in the Delhi police or not. We have already noticed the fact that it is pursuant to the needs of the Delhi police that these officials were deputed to the Delhi police from BSF following the procedure laid down in so and so of the rules and subsequently absorbed as contemplated under the said rules. It is also not in dispute that at some point of time in BSF, the appellant services were regularized in the post of sub-inspector and they were transferred as regularly appointed sub-inspectors to the Delhi police force. Therefore, on being absorbed in an equivalent cadre in the transferred post, we find no reason why these transferred officials should not be permitted to count their service in the parent department. At any rate, this question is not re integra and is squarely covered by the ratio of the judgments of this court in more than one case. Since the earlier bench of the tribunal relied upon Madhavan case to give relief to the deputationists, we will first consider the law laid down by this court in Madhavan case. This court in that case, while considering a similar question, came to the following conclusion. We may examine the question from a different point of view. There is not much difference between deputation and transfer. Indeed, when a deputationist is permanently absorbed in the CBI, he is under the rules appointed on transfer. In other words, a deputation may be regarded as a transfer from one government department to another. It will be against all rules of service jurisprudence. If a government servant holding a particular post is transferred to the same or an equivalent post in another government department, the period of his service in the post before his transfer is not taken into consideration in computing his seniority.
That is a different situation.
Here also, my lord, we were brought in identical posts as in the.
And that's understandable, but the only problem is that you see, you were under a private undertaking, government undertaking, right, earlier, from which now you have brought into the regular government service, perhaps, correct? Absorption is into a government department, which is a regular service, in other words.
Even the
Correct. So if in a way you were not present in that cadre earlier.
In the so far as the cadres are concerned, there is no dispute.
Acha.
Let's say someone was an accountant.
You are still accountant here.
I am an accountant.
But the
here.
only thing is that you were an accountant earlier in another establishment under the government, no doubt. Under the government.
The situation would be similar for the simple reason.
See, because transfer is a different situation,
No,
right?
here-
Transfer from agriculture department to education department, one can understand. Transfer from one place to other place in the agricultural department is also understandable. You cannot say, ki, no, for that period you stayed in Karimganj, we will not take into account now from here. That cannot be. That situation cannot at all arise. But as a matter of right, you may not say that, no, everything can be given. This is an equity. Perhaps the concept of equity will come here.
With greatest respect, Malad, the principle, the ratio laid down in this judgment would be squarely applicable for the simple reason.
See,
I will take-
only if it fits in the context of the present case.
Here it
Correct?
is in the context of deputation. Which is a similar
Deputation.
situation.
Deputation, but in the government departments. Now I am only trying to fit the ratio of this in a situation where it is between a government undertaking and to a government regular. I am just trying to fit in there. Follow.
Just to respond to your lordship's, I appreciate what has fallen from your lordship. Just to respond to that, my first answer would be, our question of absorption itself would not have arisen had it not been a government organization.
That's why I said equity. See, I brought in equity because for that
Yeah.
situation.
And also the broad ratio laid down.
Because the very fact that you're trying to observe them, it defies the very equity if you don't take the past survey.
Exactly.
I am
Correct.
with you as far as that part is concerned till now. I am yet to hear the other side. Prima facie, it looks that sure injustice have been done, because in a way you are giving them this option and then you are taking away all,
Ev-
then what is the point of observing them at that end?
In fact,
And that also the absorption admittedly came after so many years. What is the point then?
just to give a realistic example, my lord, some employees, what happened? There were some employees who were aged about 57, 58 at the time of absorption. Over a period of time, he had earned several increments. So let's say the take-home salary would have been, had the organization continued, his take-home salary would have been 75,000. When they treated him as a fresh appointee, not only does he lose everything else, he gets at the entry level, getting a salary of hardly about 30,000.
And that also because that undertaking could not perform. They went into losses because of all that.
It was because of their fault. That is why that was the relevance of the context in which the judgment was passed.
These people could have gone into private
Exactly.
enterprises. They opted for, because it had a government
Exactly.
holding.
Exactly.
That's why they took that appointment.
Virtually, we were misled into believing them. And that is why the very specific direction of this Honorable Court, upheld by the division bench. And after that, this is how they treat us. Whether that is a fair way of treating a citizen in a welfare state.
Yes.
In fact, may I proceed with
Yes,
the judgment,
please, yes, please.
Madhavan judgment, which is correct.
Yes, please.
It will be against all rules of service jurisprudence if a government servant holding a particular post is transferred to the same or an equivalent post in another government department. The period of his service in the post before his transfer is not taken into consideration in computing his seniority in the transferred post. The transfer cannot wipe out his length of service in the post from which he has been transferred. It has been observed by this court that it is a just and wholesome principle commonly applied where persons from different sources, that is why I was saying that it is applicable.
Different sources.
Different sources are drafted to serve a new service, that their pre-existing total length of service in the parent department should be respected and presented by taking the same into account in determining their ranking in the new service card. So this is the general proposition of law. So irrespective of where you are drafting as a source, if you have brought in persons at equivalent posts, you have to respect the past service. That is the ratio laid down. Although the previous portion talks about transfers and deputations, as a principle of general application, it is the last sentence that is relevant. And in fact, next paragraph, how a similar view was taken in another case is also recorded. So my first limb of argument is that if your lordship holds that these people are entitled to their past service being counted, the prayers made are only consequences of this. We would naturally be entitled to the areas of salary. I will place judgments on that also. So far as the areas of salary from the date of closure to the date of absorption is concerned, one argument straight away would come as a matter of general application. Whenever this kind of a situation arises, the first argument that comes is that you have not rendered service. Therefore, how can you be paid? That has been taken care of by the Apex Court in 2007.
So as far as past service is concerned, this is the only judgment.
Well, SI Rupla is now
But
universal.
Mr. Chaudhary, I don't think this matter is going to finish today, because I'm not sure if Mr. Nayak is going to respond today or not. So it looks like it will definitely go to another week. But I would ask you to, your juniors, I'll ask your juniors rather, to get hold of, if they can get hold of a judgment in the context where if, past services of whether of the another government undertaking can be brought in for some purpose of service. You see, sometime for seniority, for in those area also for eligibility, these things are there. For eligibility, I'm sure you will find a lot, because a lot of times they opt for appointment in a regular post of government after rendering service for few years in a government undertaking. So maybe from there also we can get some help. Just look into that area a little. Otherwise, this is there, but yes.
In fact, my lord, what I can suggest is, since I have broadly laid down the parameters, contours of my submissions, it might be useful if I place the written
Yes,
announcement before,
please. Yes, please.
so that on the next date when we
Yes,
continue,
please. Yes, please.
when we continue, it will be more convenient for you.
Definitely.
I have kept it as brief as possible, but I have tried to cover all the aspects.
I generally like to dictate in court, so that would be helpful. Yes.
Your lordship wants me to continue today or not?
No, that judgment, do you want to, you can finish those judgments that you wanted to rely, that at least that part gets over.
No,
So then, if in addition to that, if you find something, you can
I'll-
place it. Otherwise, we can straight away hear the other side on the next date,
absolutely.
isn't it?
My lord will kindly take up 2007, volume 7, SSC 689.
Yes, give the other book. Because I would ideally like to have it immediately next week. Huh? So otherwise I'll forget. That is why I think it will be, since we've already invested so much judicial time, you finish your part. I will certainly give you that liberty if you come up with something else to place it before they start. And in any case, you will have a right to reply.
In that case, let me complete my part.
Yes.
The
2007, volume 7.
2007, volume 7,
Hmm.
689.
Yes.
The relevant paragraphs are 33 and 34.
33 and
34.
34. Yes.
So here, my lord, before I place the judgment,
Yes.
what has been taken, this had become a routine affair. The government would illegally deprive someone from rendering service, and then at a later point of time, they would take up a position that, well, you did not serve during this period, so you cannot be paid the salary for this
No
period.
service, no pay.
No,
No work, no pay.
no work, no pay. So this is how the Apex Court dealt with. Para 33 and 34.
This is like blowing hot and cold.
So here is the situation. It was on their promise that we opted for absorption. After that, we approached this court. This court in 2007 itself issued a direction. They don't comply. Ultimately, in 2011, after the division bench judgment, they comply. And now they say that
That also after contempt.
after division bench, after contempt. And now they say that since you did not.
You try to get hold of what happened in that contempt, that order, if
Yes, I'll-
late on that date, in case if it's
The
of
only
any
difficulty is
relevance.
those days, my lord, orders were not online.
Online.
And this is a very, very old matter. Well,
If you have the number,
I'll try
if
to.
you have the contempt number,
Well,
then perhaps the file would be there. You can give me that number also.
Yes.
If you have it, Mr. Chauhan, just see if the contempt number is available in the file. Yes.
Para 33. The matter can be looked at from another angle also. It is true that while granting a relief in favor of a party, the court must consider the relevant provisions of law and issue appropriate directions keeping in view such provisions. There may, however, be cases where on the facts and in the circumstances, the court may issue necessary directions in the larger interests of justice, keeping in view the principles of justice, equity, and good conscience. take a case where ex officio injustice has been meted out to an employee. In spite of the fact that he is entitled to certain benefits, they have not been given to him. His representations have been illegally and unjustifiably turned down. He finally approaches a court of law. The court is convinced that gross injustice has been done to him and he was wrongfully, unfairly, and with oblique motive deprived of those benefits. The court in the circumstances directs the authority to extend all benefits which he would have obtained had he not been illegally deprived of them. Is it open to the authorities in such case to urge that he has not worked but held to be illegally deprived? He would not be granted the benefits. Upholding of such plea would amount to allowing a party to take undue advantage of his own wrong. It would perpetrate injustice rather than doing justice to the person wrong. We are conscious and mindful that even in absence of statutory provision, normal rule is no work, no pay. In appropriate cases, however, a court of law may, nay, must take into account all the facts in their entirety and pass an appropriate order in consonance with law. The court in a given case may hold that the person was willing to work but was illegally and unlawfully not allowed to do so. The court may, in the circumstances, direct the authority to grant him all benefits considering as if he had worked. So this is what I was on. So here is one of those classic cases where we are saying that it was your promise, you have promised to absorb us. You don't do it. And now to take up a position that you will not be entitled. This is a case which would be squarely covered by this judgment. Now, my lord, so far as the other benefits are concerned, I'll take your lordship one by one to the our second prayer is fixation of pay scale. This again, my lord, if your lordship holds that we are entitled for our past service to be counted, this is a consequence which otherwise flows from it. However, there is a similar provision which takes care of this in the FRSR. It is FR 22.
FLSM.
Right, sir.
20.
FR 22. Again, on this, my lord, an argument might come from the opposite side, saying that you were not a government employee earlier, so this would not be applicable to you.
22.
My FR 22. My response to that would be the
Yes.
spirit of these rules will certainly apply.
Yes.
Because, my lord, before I place this, another thing I must point out to your lordship, that in the corporation, when we were serving in the corporation, it is not a matter of dispute that we were all governed by all the rules and regulations of the government. These
That's
things,
an admitted position.
that issue has never been raised at any stage, because for the purpose of discipline and appeal, the Assam Services Discipline and Appeal rules were applied. For the purposes of pension, the pension rules of 69 were applicable. So on all counts, FRSR was made applicable for the purpose of leave, etc., whatever other provision. So it was all along. Now, FR 22, this is what it says.
Yes.
The initial substantive pay of a government servant who is appointed substantively to a post on a time scale of pay is regulated as follows. A. If he holds a lien on a permanent post other than a tenure post, or would hold a lien on such a post had his lien not been suspended, when the appointment to the new post, subclause 2, when the appointment to the new post does not involve such assumption, he will draw as initial pay the stage of the time scale which is equal to his substantive pay in respect of the old post. So the idea is what is in common parlance known as pay protection. That if a particular scale is being enjoyed by a person, that scale will be protected when he moves to another post.
All right.
So FR 22 for the purpose of protection of our pay, they could not have given us the pay at the entry level. Now this third prayer is
Which is the decision you said, some decision you wanted to,
on this issue. Manoj,
so that
No,
you're
I'm
only
relying
relying
on-
on that.
I am relying on
Okay.
the spirit of
Okay, okay,
Rule 22 itself.
okay.
Now, one more aspect your lordship may, I'm sorry, Malul. Now, the next prayer is that had we not been treated to be a fresh appointee, we were
So
otherwise
pay
governed.
fixation only FR 22, na?
FR 20. Next is that we should have been governed by the Assam pension rules of 1969.
Yes,
That way, we would have got our pension
yes,
because we were appointed way back in the 80s.
yes. What, here, are you relying on some provision of that?
Malad, here, I am relying on one aspect. Identically placed was was a mineral Assam. I have pleaded that at paragraph 14b, and this has not been denied. If your lordship will kindly come to page 17,
Yes, just read.
14b. The respondents have treated the petitioners as newly appointed employees and made them to sign an undertaking and an affidavit to the effect that they will abide by the new pension scheme announced by Government of India, so and so. The respondents have failed to appreciate the fact that the petitioners were appointed in government service long before, and as such, they fall under the Assam Pension Rules 1969. Accordingly, the petitioners are entitled to get the pensionary benefit as per Assam Pension Rules. Now, next sentence is very important, and this is not in dispute. The petitioners have come to learn that some similarly placed employees like the petitioners in Assam State Minor Irrigation Development Corporation Limited have been placed under the Assam Services Pension Rules 1969. And now, at that stage, we were not very sure. That is why we have said that we have come to learn. Now we know for a fact that they have been given the benefit, whereas we have not been given a similar benefit. On this, my lord, and they have not disputed this position of fact. There is no denial of this statement of fact. On this, my lord, the fact that similarly placed employees, persons are entitled to similar benefits, there is a direct judgment on the issue.
Citation.
2015, Volume 1 SCC 347. And the relevant paragraph is paragraph 22.1.
Paragraph
Paragraph 22.1.
22.1. Yes.
At page 363.
Pension. Page.
It starts at 347.
Okay. Okay.
Relevant paragraph page is at
Yes, the second last. Yes.
363.
Yes.
22.1.
Yes, I've got it.
The normal rule is that when a particular set of employees is given relief by the court, all other identically situated persons need to be treated alike by extending that benefit. Not doing so would amount to discrimination and would be violative of Article 14 of the Constitution of India. This principle needs to be applied in service matters more emphatically, as the service jurisprudence evolved by this court from time to time postulates that all similarly situated persons should be treated similarly. Therefore, the normal rule would be that merely because other similarly situated persons did not approach the court earlier, they are not to be treated differently.
So, but here, in this case, someone has got.
Yes. Minor irrigation.
No, that is a different department.
Different department.
From where?
They also migrated from a corporation. Minor irrigation.
You have that case.
We have made that statement, we don't have that.
No, but then you find that out because
we'll try to
otherwise it's
get-
quite a vague statement because we don't know.
No, this is not in dispute, man.
No, but true.
We
But
move on
now,
back, we
if
have
I
very-
have to author this judgment,
Huh.
perhaps then I might have to look under what
I'll-
principle. If I want to go to that respect, you see, Mr. Chaudhary, I understand they may not have denied it. It could be a fact, but then it would only assist your case and
Yes, yes. We'll try
the
to-
court. You see.
My only difficulty is, my lord, the matter is so old. Many of the
True,
persons
true.
are-
No, but this is, you see, this is nothing for those people to give you. Perhaps your juniors will have to burn some midnight oil
No,
to
but-
find out if they can get hold of that decision from the online.
Our statement does not say that it is pursuant to a direction of this honorable.
Oh, acha.
If they have been directly given, that is something we are not aware. If they have been given by the
Can you
government,
find out from the minor, from that department, because it's also a government department. Try and find out if something has been done. Ultimately, you see, you have to be also fair to the court. If that is done there, whatever be it, of course, it would be in the facts of that particular, but you place it if it is
they
there.
were similarly closed. That corporation also was similarly closed like ours. They were also absorbed. They are also were given options. They were absorbed. On absorption, they have been placed under the old pension rules.
Because if I have to go into that aspect, I will need more clarity.
Yes.
Otherwise,
also try to
it's a
find
bit
out.
vague. You see, it's neither here nor there. We don't know under what circumstances or what has happened in that case.
I'll try.
Yes.
I'll also try to check up if there is any material to show that. Now, my lord, the next prayer is gratuity, my lord. Again, if your lordship holds that we are entitled to counting
I
of
followed. I mean, main issue is that if that is in
The
your
only-
favor, the consequential benefits will also come. This is what basically.
your lordship may just make a note of the relevant rules.
Yes, just give me that.
So far as the next prayer is concerned,
Gratuity.
it pertains to gratuity. The relevant rules are Rule 135(1) and 135.
Rule 1.
135(1).
Yes.
Sub-rules 1 and 3 of Rule 135
Yes.
of the Assam Services Pension Rules 1969.
Assam versus
Pension.
pension rules.
FRS and company.
Please. 135, 1 and 3.
Now, my lord,
Yes.
if our next prayer pertains to
Leave.
salary in lieu of
What
what
about
is known
leave?
as leave encashment, my lord.
Yes. Number
This
D.
was under the FRSR, there was an executive instruction issue. If we are-
FR.
FRSR only.
I don't think we are having the same book, but yes. Where do you want me to turn?
It is just after Appendix 11. In my book, it is at page 406. Ekhon nine. It should be just after Appendix 11. my lord.
I don't think.
ये असम का है कि नहीं?
এইখন কিয় আনাই নলয়? That is a good book.
असम लॉ हाउस का पब्लिश
এইখনত ডাঙৰকে এইখন আপুনি আনাব ক'ব তেওঁলোকক লাগে এইখনত চব থাকে কমেণ্ট্ৰিজ খিনিত
सेंट्रल अफेयर्स तो नहीं है कहीं। देखो देखो अपेंडिक्स 11 निकालो। पहली बार शायद अफेयर्स देख रहा था मुझे।
earlier sometime because of such situations I remember back those days the chambers that I was associated with used to ensure that we carry
एक्स्ट्रा बुक
extra books not just the case laws the books I'm talking about my days in my senior chambers
लेट 90s।
for me it was 2000 but that period but yes
Those were the golden days, man. I still remember.
Because
one-
I asked the courtmaster that why don't we have that book? Because generally all councils come up with that hardbound book.
And this is the latest act.
Correct. So we must be also having a copy
Must-
here. And he says we don't have this in the library.
Or this is just for one, your lordship. may
Yes,
just have
yes,
to
yes.
look
It will
at
save the time because I have the entire board. I can see the tireless faces
I'll
of the
also wrap up-
councils waiting for their matters to be called.
I'll wrap up in 10 minutes.
No, no, no. I'm not saying that. You take your time. This case definitely needs some time. Yes.
If your lordship has a look at that page, your lordship will find that on the left hand side, there's a OM. In
The
front,
highlighted portion.
highlighted portion.
Yes.
So earlier, the leave encashment was for 180 days. In fact, that has since then been amended and it has now been made 240 days after 2000. इसका extra copy नहीं है. That has not been, for some reason, the amendment has not come in the FRSR. What was earlier,
Just 1 second, Mr. Chaudhary. Let me just understand this OM that you are first placing. Okay. Yes.
so basically the earned leave keeps accumulating throughout the service
Yes, yes,
career.
yes.
And at the time of his retirement,
It
he
is
would be
given.
entitled to.
So you have now, because you have been brought out and that has been wiped off. So this is gone. Whatever contribution, whatever is pending in your
Whatever leave I had earned,
entitled that you
it's
have
all gone.
earned. It's all gone. Okay.
this again otherwise would
এইখিনি
be a
কিন্তু
consequence.
লাগিব তাত নাই যদি ফটোকপি কৰি এফালে থৈ দিম yes
And so far as the salaries is concerned,
for
I
that
already-
gap period yes
the only thing that remains is the value of the undertaking. Those
Yes.
two judgments, my lord.
yes yes
What would the undertaking entail in this kind of a fact situation? It is Brajanath Ganguly, the famous landmark judgment.
yes
Citation is 1986.
Nineteen
1986,
yes 3 SSC 156 paragraph
156. Relevant paragraph, it's a very, very long judgment,
Yes.
my lord. I will just give the relevant paragraphs.
yes
76,
70
76, 83 and 89.
76 76 80
83,
and
89.
80 yes undertaking no
But, and in fact, even these paragraphs are very, very long. I'm just reading out the relevant portions.
yes
Your lordship may first come to 76 at page 206. The very first sentence absolutely hits the nail on its head.
yes
Under which head would an unconscionable bargain fall? If it falls under the head of undue influence, it would be voidable. But if it falls under the head of being opposed to public policy, it would be void. So in this case, it would be opposed to public policy, therefore it would be void ab initio.
yes
Now, this rest of it talks about that particular case. Now, if your lordship will kindly turn to para 83. In fact, 83 to 91, all these paragraphs deal with this principle, how it has evolved. I'm not troubling your lordship with the whole thing. Your lordship will first come to 83. In fact, I'm not even troubling.
yes
All the prior English laws, etc., have been discussed in paragraph 83.
Yes.
84 also discusses the law. And in fact, para 89, it starts at 215.
83 starts at 200.
Para 89 starts at 215. I'd like to, my lord, place this paragraph. So all the English laws have been discussed.
Yes.
Thereafter, how this principle was accepted in our courts is recorded here.
Yes.
Should then our courts not advance with the times? Should they still continue to cling to outmoded concepts and outworn ideology? Should we not adjust our thinking caps to match the fashion of the day? Should all jurisprudential development pass us by, leaving us floundering in the sloughs of 19th century theories? Should the strong be permitted to push the weak to the wall? Should they be allowed to ride roughshod over the weak? Should the courts sit back and watch supinely while the strong trample underfoot the rights of the weak? We have a constitution for our country. Our judges are bound by their oath to uphold the constitution and the laws. The constitution was enacted to secure to all citizens of this country social and economic justice. Article 14 of the constitution guarantees to all persons equality before the law and equal protection of the laws. The principle deducible from the above discussions on this part of the case is in consonance with right and reason intended to secure social and economic justice and conforms to the mandate of the Great Equality Clause in Article 14. This portion is very important. This principle is that the courts will not enforce and will, when called upon to do so, strike down an unfair and unreasonable contract or an unfair and unreasonable clause in a contract entered into between parties who are not equal in bargaining power. It is difficult to give an exhaustive list of all bargains of this type. No court can visualize the different situations which can arise in the affairs of men. One can only attempt to give some illustrations. For instance, the above principle will apply where the inequality of bargaining power is the result of the great disparity in the economic strength of the contracting parties. It will apply where the inequality is the result of circumstances, whether of the creation of the parties or not. It will apply to situations in which the weaker party is in a position in which he can obtain goods or services or means of livelihood only upon the terms imposed by the stronger party or go without them. So now, here, since the word contract was used, there were subsequent cases where it was pondered whether this concept, unconscionable contract and lesser bargaining position, would be applicable only in the sphere of contracts. That debate got subsequently settled. In fact, our High Court judgment, my lord, I'd like to place. Identical situation happened in the education department. This is, my lord, 2011, volume 2 GLT 51.
This is Justice Rishikesh Roy
Okay.
judgment that you are referring to.
In fact, I had the occasion to,
Yes, you
Appear.
mentioned.
and
Yes.
relevant paragraphs are, I am not troubling you, Lordship, my lord. The facts are narrated. Paragraphs 10 to 13 are relevant.
Paragraph.
10 to 13.
Yes, please.
So exactly same situation in the education department. They were also made to sign an undertaking.
Yes.
And I had raised this plea that they were in a much lesser bargaining power, and applying the principle of Brajanath Ganguly. Brajanath Ganguly is referred to in paragraph 12, referred and relied on. And a subsequent judgment, my lord, Sharma,
Very well. It's okay.
and based on that, areas were directed to be paid.
Blindest clip body. Yes.
So therefore, my lord, looked at from any angle,
FRSR কপিটো ইয়াতে ভৰাব ফটোকপি কৰি এটা ফটোকপি লাগে আৰু এখন OMG ডিসপ্লে এখন কাগজ Yes.
therefore, my lord, to sum up, firstly, the legal principles and even we completely keep aside the individual judgments, etc. Just equity, justice, and good conscience, fairness, which are very integral facets of Article 14. These demanded that we ought to have been treated fairly. Our past services ought to have been considered, so that at least at the fag end of our careers, we would get something. Having rendered our services, it may not be a government department, but ultimately it's an instrumentality of the state. We have rendered decades of service. Would we not be entitled to be treated fairly?
Very well.
Reserving my right of reply.
Yes, yes, of course, you have that. And before even, I'm again making it clear, before I hear them on the next date, in case you come up with something
Yes.
on those two aspects.
Yes.
Number one, that undertaking, if you find something, and that
Mineral.
that mineral, in
Yes.
case you get hold of that, in case.
Yes.
Otherwise,
I'll try to
yes.
get my juniors to contact the clients if possible. We can get any materials.
Maybe from what was that mineral initially? Do you have an idea? What was that establishment from where they have come?
Mineral Development Corporation.
Corporation.
Assam Mineral.
So maybe somebody in the government or in the department might know.
Yes.
You can ask them to speak with the government councils are very cooperating otherwise. So
I'll try
I'm
to-
sure you'll have friends there.
Hmm.
Yes.
Lordship, on the next date, we.
When? Mati Diop?
Any date convenient to you?
Next week long. Suggest any date next week.
Let it be a hearing day, my lord.
Yes, yes.
Either 4th or
Yes.
6th.
Yes.
Six.
Sixth. Sixth. And see, you have already heard, and I'm sure a copy of the written argument is
We are
also
already-
shared with you, right? So you also give us a small note of your reply, whatever you want to indicate. You have it. So do you want to give that right away? এইখনো লৈ লওক। You know what, in case you see, after hearing them, if there is something else you want to add, you can do it and we can replace the notes on the next date. All right, I'm giving you that liberty. You can take this back on the next date and give me a replaced one in case you want to add something, because you've heard them today. So that is why I'm giving you that liberty. Of course, this matter was heard earlier, so I'm sure you both know your the cards of each other. It's only with time now you have improved. A chance has been given to further improvise your arguments, maybe for the benefit of both parties. Yes, heard Mr. I. Chaudhary, Leonard Senior Counsel, assisted by Mr. R. Chauhan, Leonard Counsel, appearing for the petitioner. Stop. Also heard MS R. Bora. Somehow I always get confused with your title, surname. Sorry, not title, surname. Rashmi Bora Das. R. Bora, Leonard, Standing Counsel? Standing Counsel, Agriculture Department. Mr. Chaudhary so-and-so has concluded the arguments for the petitioner. MS so-and-so seeks posting the matter on any date next week in order to enable the Mr. Nayak, Leonard Senior Counsel, Leonard Additional Advocate General, to give the reply arguments on behalf of the Agriculture Department. Relist on 6 so-and-so for further hearing. Matter be treated as part heard. In the meantime, the written argument submitted by both parties is also taken on record.
Obliged.
By slip.
Item number 9.
Item number
Nine.
9. Yes, Mr. Mohanta.
My lord, this matter relates to my lord. My lord, the withholding the promotion of the petitioner, my lord, to the post of inspector, sub-inspector, general grade, general, my lord, duty from the post of the head.
Just one sec, Mr. Mohanta.
My lord.
Just one sec. A2 case, sir. মোৰ নোটটোতে লগাই থৈ দিয়া আৰু ইয়াতে আনি চাবি আজি ডেটটো দি থৈ দিয়া পোষ্ট অফ
From the post of head constable, general duty to the post of
হেড
sub-inspector,
কনষ্টেবল
general duty.
জেনারেল ডিউটি
My lord,
ইয়েস
to the rank of sub-inspector. general-
সায়েন্স
Sub-inspector.
সাব ইন্সপেক্টর
Sub-inspector, general duty.
ইয়েস
That is been came into force, my lord, by the order of the SSB headquarters. That is on 16/5/2011,
ইয়েস
by which, my lord, the junior to the petitioners were promoted, my lord.
ওকে
So that was the case, my lord. So as per this, my lord, as per the recruitment rule of promotions, my lord, it has been annexed in the reply filed by the respondent side. Its rules came into 2009, my lord. And by this rule, it is stated that the 50% of the promotion from the cadre of this is head constable general duty to the post of the sub-inspector general duty should be filled up by promotion. And the criteria that to be fulfilled, that 18 years of service rendered in the federal post, my lord. And the second, my lord, they have to pass class 10 standard, and they have must qualify the prerequisite qualification, that is, my lord, the undergraduate, that is course is to be qualified and that to be passed out. So, my lord, the petitioner, he have completed all the categories of this criteria, except, my lord, the 18 years of statutory period that have to be completed during the, my lord, before going for the promotion. So he has yet to be completed 18 years, by left out only 2 years, 6 months for 21 days or like that, my lord. But the thing is that when the panel was prepared, the petitioner case was, my lord, taken into consideration, and he was also given the promotion by the DPC. But as he is not completed the 18 years of statutory period, otherwise he has completed all the qualifications. So his case was, along with the others, my lord, sent to the Ministry of Homes, the central government, for the recommendation, but that was rejected. So on that, my
But
lord,
you did not have the statutory period of service.
yes, my lord, that may be
That's
my
an admitted
this is the
position.
admitted position, but not.
And do they have a power of relaxation?
But thing is that, my lord,
Because if they have, in case the recommendation was allowed, then someone junior, some other candidate would have come up by way of a 226 and said,
That is-
that relaxation is given, you have given promotion to someone who does not have that specific.
yes.
You understand, Mr. Mohanta?
Yes, I understood.
Maybe that on that, if that situation arises, you would have not be standing this side, but that side.
Yes, that is no, my lord. But thing is that, my lord, is in similar circumstances, just before our promotion, that is in 2011, that was occurred in 2010. In similar circumstances, many of the, my lord,
Those matters came before the court.
they did not came, but they were
Then
promoted.
that is an illegality perpetuated.
lord.
We cannot perpetuate that illegality.
But that was, my
You see, if you show that they have the power of relaxing, that they have relaxed, or that they could have, then different. But if that power doesn't exist, where is the question of relaxing? And in any case, it's the government who will take the final call. Admittedly, you don't have that statutory service.
but the thing is there, my lord, the relaxation power that has been, my lord, mentioned in the, my lord, the DPC, as well as the letter forwarded from the department concerned to the MOE, my lord. The whatever, my lord, stand is taken by them, that was rejected. But so far the rejection order is there. No document has been, my lord, furnished to us and not been
Not
recorded.
necessary. It's a
That is-
promotion.
It is not been produced, my lord.
No, that is not required.
But thing is
Now,
that-
for promotion also, if they take a call, everything cannot be
but
communicated to
prior
you.
prior to our similar circumstances, my lord, many were promoted by relaxing.
Could be, Mr.
They have also not
Mohanta.
completed the 18 years
Could
of
be.
periods, my lord.
You first of all, under the service rule, that is why I'm repeating
Yes,
the
yes,
question
yes,
to
yes,
you,
yes.
Mr. Mohanta.
That is,
Under the relevant service rules, that power of relaxation exists?
but it is not mentioned in the service. rule.
Correct.
This
So
one.
it is not
Not
there,
there.
but you see, sometime for humanitarian purpose, they may. It could have been that the government could have relaxed. I'm not saying in that situation, if a challenge comes, on that day we would have taken a call. But that is not the
I-
situation today, Mr. Mahanta.
My lord, very much agree with your lordship, my lord, whatever my opinion is
So,
there.
so,
But thing is there, my lord, considering
and
the,
um,
only my lord, one thing, my lord, considering the vacancy numbers of posts, that is in more than 6 to 645. But the only 300, my lord, were found eligible, and accordingly, as the, my lord, my criteria, so far the other criteria has been fulfilled, except my lord, only 2 years has been left to complete my 18 years. So that was sent for the government for the, my lord, recommendation.
2 years
2 years, my lord,
for 18 months.
18 years.
So the
That will
criteria
be
was
possible.
18
Yes,
years.
Yes, my lord. So 2 years was, my lord, they left out to be completed, but this is my case. So
Where
my-
is this 10 in your affidavit?
Yes, 10 years there, my lord, but
Where?
it is, they have filed on, my lord.
Yes, I have it, page 34, the
Yes,
affidavit, sir. Just
Yes.
give me that paragraph.
They have stated a paragraph number 5 of their affidavit. 5,
Prior to that also, we have stated that qualification.
Give me that paragraph.
Lordship,
Mr.
paragraph from paragraph 3, page D.
Yes, I've got it.
Paragraph 3, clause D.
Because you see, initially you said that they were included. That is not going to give you
DPC, my lord, concept come into the
They-
consideration.
Then also,
correct.
but
You see, but that will not give you any right.
I absolutely, my lord, agree with your lordship, but I want to rely on judgment only to that effect, my lord, my lord.
All right, give me.
This is,
See, I would have liked to help you. My empathy is there,
my lord.
but I'm tied by what to
Yes,
do.
yes.
and apart from that also, Lordship, it's a promotion in the year 2011, and now.
Yet
he
been
asked-
12. This petition is filed in
Yes,
2012.
He is
Immediately, ma'am.
that post
It's
regarding that.
unfortunate that this petition has been pending till 2025. It's
That-
very unfortunate, but nonetheless, the petitioner had come immediately.
He came, but the post, etc., were now.
Whatever, Ms. Sharma. It's not that he has filed this petition after 20 years, isn't it? You have a good case. Why are you going to that area unnecessarily?
My lord, says-
You have a such a strong
But-
case.
But so far my reply is concerned, my lord, to this counter. So in my affidavit, my lord, I have specifically.
Because you see, it is the government's call. The court in 226 is only trying to see if the government has acted fairly or not. That's all. The decision-making process. The
No, my lord,
government has taken a call, and the government has done as per the rule, as per the relevant. What is this rule you have cited here? Recruitment rule.
2009.
Correct. Under that, the specific prescribed period required is 18 years of service, which admittedly the petitioner doesn't have, so he's not qualified. So where is the question of promoting him? And you have rightly rejected it. That's it.
So
Yes. What do you want to show?
My lord, this probably is not available here, my lord. I want to show, my lord, the Union of India versus, my lord, Munshi.
Yes. What does it say?
It is, my lord, it is here, it is
Yeah,
saying,
Gibo.
my lord, although, my lord, this promotion is not a right, my lord, it is very much correct. But this, whenever, my lord, it is discriminately, my lord, decided by the authority concerned.
All right.
So 16(1), my lord, that.
Okay,
my lord,
okay.
come.
I'll take
So-
that in mind.
So this is my.
Yes, all right.
So to that effect, my lord, I want to show, my lord, one my.
Constitution. All right, that is on discrimination. I've taken note of Mr. Monta. I'll deal with it.
No, my lord, only one thing, my lord.
Yes.
My reply, the counter, this is para 3, my lord, I have specifically mentioned.
Yes, you give me the paragraphs. I'm going to dictate it in front of you. So I'll include everything. Yes.
This is, my lord, para number 3, my lord, I have specifically mentioned, my lord, and document also I annex, my lord.
Where's the reply?
It is reply
It
was.
starts with at page 41.
It is not really, my lord.
Ah, yes, it's at 41. Tell me the paragraph.
Paragraph 3, my lord.
Yes.
With regard to the panel, not say what you mean.
I further say that such notification, the first DPC was convened in 2010 for appointing so-and-so by audited so-and-so, several incumbents, Niranjan so-and-so, had not completed so-and-so, instant upon so and so release is yet to be clarified. Moreover, out of so and so to be feel thereof being promotion as regards so and so, I say so and so. In fact, that I did not find merit. Is not understood as to what merit was found in the matter of releasing the criteria 18 years. In case of so these are the similarly
Say C2FF, my
Okay.
lord. So their case was considered as a document. I have annex, my lord. This is the annex.
very well, very well. That
Annex
page
third.
what? Page what?
It is
Document
annexed
that
at
page? Page.
page, my lord, next page, my lord.
The document is in the next page.
Yes, my lord.
No, 43 is the affidavit.
It is, my lord.
Yes,
Annex
page
at-
44.
Yes, my lord. Annex D at page.
Page
10.
44.
Yes,
Okay.
So wherever 2%, my lord, I am showing.
Yes,
It
Mr.
is-
Mahanta, I've understood.
Yes, my lord.
I've understood.
Yes,
This
sir.
is how you want to bring in discrimination. I've understood.
So-
If
so
there is
I want
something,
to rely
no,
this
no,
on
it's
it.
okay. If, you here, in case you want to add something more to your submission, I'll add it. I've understood. That's why I'm rushing it. I don't mean
Yes.
to cut you short or not hear you.
Lordship rightly hold the things, my lord. I am not disputing that, right?
It is just that sadly, you see, you don't have it now. The view of this court is that this court is not going to perpetuate an illegality. According to this court, granting this thing to Niranjan Roy Tilak Singh would automatically not entitle someone else also for the same thing, because otherwise the service rule is clear.
The service
You see,
but yes,
I am
sir.
on that.
But the decision I
That is you see, that is a discretion of the government.
But this is
You see,
this-
I would have understood if the government would have similarly relaxed you, but you cannot, as a matter of right now, urge that no, you've done it for A and B, now you have to do it for me. That you can't.
that is absolute-
But you see, in short, you are asking for
no,
that.
madam, this case is showing, this specifically showing, but if something is considered for a particular section of
Correct,
people,
correct.
that cannot be said.
That's
that
what I'm
negative
saying.
equivalent.
In other words, you are saying that only.
That will negative
But,
equivalent not come in
but
that. This is
that
the
will
idea.
not now give you that. Yes, they could have.
Must-
They could have, but you see, they have not. Unfortunately,
Must-
that's why I said I have the empathy also with you. It's like my heart is with you, but my mind
Yes, yes.
is not being able to connect with my heart and give you that relief.
Yes, madam. Right.
Heard Mr. P. Mahanta, na?
Yes, madam.
Mr. P. Mohanta, Learned Counsel appearing for the petitioner. Also heard MSC Sharma. B. Everywhere your name, I don't know why the initials are being all changed, and that's why I keep getting confused. B. Sharma, Learned CGC. CGC. By way of this instant petition under Article 26 of the Constitution of India, the petitioner is assailing the impugned rejection of the claim of the petitioner for promotion to the rank and post of sub-inspector within bracket general duty with effect from the date of promotion of respondent number 4 to the said rank and post in terms of order dated 16/5/2011. Full stop. Inter alia corridiba. The brief facts of the case is that the petitioner was working as constable general duty in the Sashatra Simabol as on 5/8/1995. No, from 5/8, from, right?
Madam.
You're working from, right?
Yes, madam.
From 5/8/1995. Yes, take your seat. No.
Madam.
5/8/1995. And thereafter, he has been. No, was initially working corridor, as constable so and so, and thereafter corridor. He has been employed to Nidiba, and thereafter he has been employed in the armed force as an integral part thereof. Initially on 5/8/1995. That date to upor lagao. Bujhila? It is the specific case of the petitioner that it is a specific case, Nokoba. It is the further case of the petitioner that the respondent number 3, that respondent number 3, no, it is the further case of the petitioner that in the draft seniority list of the head constable general duty published by the respondent number 3, right, office memorandum dated 21/2011, comma, the petitioner's name appeared at serial number 297, whereas respondent number 4's name appeared at serial number 298. Stop. Pertinent that the petitioner was promoted as Nayak NK general duty on 29/6/2002, whereas respondent number 4 was promoted to the said rank on 13/7/2002. Thereafter, the petitioner was promoted to the rank of head constable general duty on 5/9/2005. Though the respondent number 4 was promoted as head constable general duty on 5/9/2005, however, he was further promoted to the rank of sub-inspector general duty by order dated 16/5/2011. And the petitioner was promoted to the rank of assistant sub-inspector general duty on 26/6/2012 with effect from giving effect from 25/6/2012. Correct, Mr. Mohanda? I have correctly stated.
My-
It is the specific case of the petitioner that the petitioner was not promoted to the rank and post of sub-inspector general duty in view of the fact that the petitioner did not have the requisite 18 years statutory period of length of service under the applicable rules, inasmuch as the petitioner falls short by 2 years,
6 months.
6 months of the said statutory period of length of service. Stop. Since However, it is the contention of the petitioner that the requirement of 18 years of service as contained in the applicable recruitment rules is of no purpose. Since, inasmuch as when the question of seniority in rank and length of service are to be considered for awarding the benefit of promotion to a higher rank in that situation, seniority in rank is always required to be preferred. And for this purpose, the requirement of length of service deserves to be relaxed in the interest of justice when promotion is recommended by the DPC. Stop. In the instant case, since the DPC had recommended the case of the petitioner for promotion, comma, relaxation of the said statutory minimum period of length of service having been denied to the petitioner, the present writ petition has been filed. Correct? Mr. So-and-so Mohanta submits that since the since the government has since the government did not relax the statutory minimum period of length of service, despite the recommendation of the DPC, comma, the claim of the petitioner for the subject promotion warrants consideration. Stop. He further submits that since in the case of similarly situated persons, two similarly situated persons, the government has relaxed the said statutory minimum period of length of service, comma, non-relaxation in the case of the petitioner amounts to discrimination, and hence Article 16, 16 so and so of the Constitution is clearly contravened. Gets clearly is attract and attracts accordingly. Stop. Per contra, that is all your submission, isn't it? Your submission is only that?
Yes, ma'am.
He accordingly submits that the petitioner's claim for the subject promotion having not been considered fairly in an equitable manner, the action of the government for non-relaxation of the said statutory minimum period of length of service warrants interference from this court under the extraordinary writ jurisdiction. Per contra, MS So-and-so Sharma, learned CGC, submits that under the give him a pen. Under the recruitment rules, the minimum statutory period, length of period of service prescribed, having been prescribed, comma, any non having the aforesaid minimum requirement of length of service would disqualify the candidate for the employee for promotion to the post in question. She further submits that any such relaxation would be in violation of the statutory rules, inasmuch as under the recruitment rules, no such relaxation is provided. Yes.
Lordship, respondent number 4, he had already completed that required criteria because at paragraph
Who's
4
four?
that he had challenged whose promotion, he had that criteria.
She further draws the attention of this court that though in the writ though the writ petitioner has based his case in the petition on the basis that the respondent number 4 did not that the case of the respondent number 4 was considered despite not fulfilling.
No, I'm not, my lord, sorry, my lord. He is junior to me. So that is the on the ground, although he is.
Okay,
fulfilled.
that is all right.
Only
Mr.
junior.
That is okay.
I'm not.
That today he has not even placed
I'm not.
because he is not on that.
I'm
he's
saying
not
on
on
the
that.
junior that he was considered.
Yes, I've understood. That has already come in your argument. Yes. No, I have heard the learned parties and have perused the materials available on record. Yes, where do I get that rule? The core controversy arising in the writ petition is whether the petitioner is qualified for promotion to the post of assistant post of sub inspector so and so on.
I have annex 1 Xerox copy.
Where do I
annex
get
of
it?
1 of my affidavit.
Next one.
This is going to be so difficult. Ms. Sharma, this is going to be so difficult. Where do I get reference of the rule? Apt at the outset to refer to the eligibility criteria for promotion of HCGD to the rank of SIGD to full form which is provided under GSR 845 of the Recruitment Rules 2009, dated 25/11/2009.
40.
Next one.
Now that I have, but the problem is it does not have a head or tail.
Yes, that is it. But
It is headless and tailless.
But
Now
this is with me, but the rule by this person is not there, right? It is a
no,
new
this is not.
it is formulated by some.
They have given a date. No, as per that. No, which reads as under Korea to Didiba, huh? Ekute bostu Didiba. Reading of the aforesaid, it appears that in order to be promoted, in order to be qualified to be promoted to the such and such post, the head constable general duty amongst of SSB, who with 5 years regular service in the grade together with total 18 years of service is required. The minimum minimum length of service prescribed for head constable so and so of SSB is 5 years regular service in grade together with total 18 years of service. Full stop. This position is not disputed. However, since the petitioner does not have the requisite 18 years of service, he was not given promotion to the so-and-so post. It is undisputed position that the petitioner had fallen short of the requisite 18 years of service by 2 years. Yes, Mr. Monta?
2 years, 6 months.
2 years, 6 months. Now, the question that arises before this court is whether the government can be said to be at fault for not relaxing the minimum statutory so and so in the case of the petitioner for considering promotion to such and such post. Apt at this stage to refer to the relevant paragraphs of the affidavit in opposition filed on 5 June 2013, which reads as under paragraph 3 preamble 35 what আছে. It goes on A, B, C, D. এখানে লৈ লবা. Paragraph 4, paragraph 5, paragraph 6, paragraph 7, সব দি দিবা. 7 or like. Also to refer to the affidavit and reply filed by the petitioner against the aforesaid affidavit in opposition filed by the respondent on 3/8/2015, which reads as under paragraph 3
and 4.
and 4 and 5. Okay? Reading of the above material, above reading, having perused the above pleadings extracted herein above, it is apparent that the central government, now it is apparent that the petitioner is not having the statutory minimum period of length of service for consideration for promotion to the post of sub-inspector so and so. That being so, the non-consideration of the case of the petitioner by the government despite the DPC cannot be faulted with merely because the DPC recommends the case of the petitioner for promotion, it automatically does not give any right to the petitioner for promotion to the said post, nor does it automatically entitles, nor does government blindly on the basis of such recommendation has to promote such and so and so give effect to the said recommendation. At that stage, the government has to act fairly, has to act in a transparent manner, consistent with the principles of, consistent with the service rules, applicable service rules and fair play. Stop. Since under the service rules, since under the recruitment rules in question, admittedly the petitioner did not have the requisite so and so, this court does not find any infirmity or illegality on the part of the government for non-considering the case of the petitioner for promotion so and so. As regards the contention of the learned counsel appearing for the writ petitioner to the effect that two similarly situated persons, in the case of two similarly situated persons, the so and so period having been relaxed, suffice it to say that illegality cannot be perpetuated by this court under exercise of 226 jurisdiction. Petition fails, dismissed. Sorry, Mr. Mohanta.
My lord, only one, my friend, my lord, one decision I rely, my lord, that if it is fairly reflected, my lord. that-
Discrimination.
Yes. my lord.
I'll deal with that. It will be
Para number 6 and
Uh,
7, my lord.
Buddhiman, that decision is not applicable to the context of the facts of the instant case, in as much as this court does not find in any manner the petitioner have been discriminated. Stop. In view of the fact that the petitioner does not have the requisite so and so under the rules, and it is not, and the rules does not give authorizes the government to exercise the power of relaxation. Sorry for the delay. I had another judgment in court too. So
Moreover, Lordship got up late.
a little late.
So no issue, Lordship.
Yes.
Lordship, in this case, we have very limited, the appeal is on limited ground. The appeal is on the ground that there was no policy issued at the time of accident. What
There
happened?
was no policy.
No policy. The accident.
Insurance policy.
Insurance policy. The accident took place as per our evidence. We adduced evidence, insurance company. Appeal is filed by the insurance company. 4 witnesses, 4 DWs. One is official of the insurance company. 2 is the person who kept the register in the hospital where the deceased was admitted. 3 is the police official.
iPad.
Police
Yes.
official who filed the charge sheet, and 4 is the doctor who treated the deceased, Lordship. All these people, they showed that the accident, the treatment and the accident had taken place at morning in the 9:15. But what the owner of the vehicle did, Lordship, was that he took a policy at 1:32 of the same day when he came after. So we proved that at the time of accident, there was no policy. So, Lordship, since that is the case, we are not liable. Our own High Court judgment is there, Lordship.
Then on what basis the impugned judgment was given? Because that position is admitted, that your policy admittedly was post
Yes, Lordship.
the accident on that date.
I'll read one paragraph. The paragraph number is not there. Page 11 of my memo of appeal, Lordship. And internal
Paragraph.
11. The paragraph number is not given, Lordship. The
Memo of appeal filed before where? This court.
yes, Lordship.
There's no
Page 11.
page 11.
There is no paragraph in the judgment, Lordship. Paragraph.
Okay. Okay.
On
careful perusal.
yes, on careful perusal of the exhibited documents and the evidence of the witnesses, it appears that at the time of accident, the vehicle was not insured. And immediately after the accident, the owner of the vehicle, with the help of police, insured the vehicle with the insurance company. So the court came to a clear finding here. Thereafter, so I am of the considered view that basing on
And
the
you are the
accident-
insurance company.
insurance company. Basing on the accident information report, which was issued by IO Harish Chandra Sharma, the claimant is entitled to get compensation from the insurance company limit. So, Lordship, totally contradictory.
How can it be? How is it that the claimant is entitled to get compensation from the insurance company when there was no insurance at the time
Yes,
of the accident?
yes, Lordship, that's why we filed the appeal, Lordship.
You are for the claimant.
Yes, my.
So, but how ultimately on this basis they found you to be entitled, and then the rest of the part of the judgment must be the computation, correct?
Yes, Lordship.
But Mr. Counsel, how is that?
My lord, may I submit my?
Yes,
My lord, if your lordship comes to the paragraph 11 onwards, my lord.
paragraph.
I mean, page 11, that's
Yeah.
Planet 10, right? Come to the last paragraph of the paragraph 10.
You are Mr.
Ah,
Majum.
Clement.
No,
Not
you're
Clement.
Majumdar, right? No.
I'm Mojumdar.
Please,
She,
No, that
Patel
I
Bhatt.
know you, but
Yes.
no, here
Clement only.
your name.
Yeah, but she-
K. Bhattacharjee. Yes. Correct. That's why I got confused.
So.
No, I just saw that name. That's why I was a bit confused.
Page 10, last paragraph. The findings of the tribunal. Because I have nothing to do with this case, my lord, between the owner and them. If the insurance is liable, as per the Supreme Court, they should
Who's
pay
for
me.
the owner?
None has appeared, my lord. Because as per the Supreme Court,
See, as far this
I'm
court
just
is
comparing.
concerned,
Yes.
right now the insurance company is before this court.
that means.
Now, it appears that the insurance company does not have any liability as such. You are right when you are saying that someone has to pay. Now, but that doesn't mean that we fasten this liability on this particular insurance company for something on the date on which there was no insurance policy.
You're right, Lordship, but the
Correct.
principle has been laid down by the apex court that whatever may be the reason, you first pay and then recover from the owner. I will place the judgment.
No, but that would be perhaps in the context of that case. In that case as well, there was a post insurance.
Same case, my lord, same case.
Same
proportion,
kind of
same-
facts.
Yes.
Well,
that's
we will see.
all. Yes.
Come,
So
I
your
have
lordship
gone
will come to
through.
the paragraph,
No.
page 10.
Yes,
The paragraph I will read. I have gone through the evidence, your lordship. got it.
yes.
I've gone through the evidence on record and the documents submitted, particularly from the accident information report. It appears that the accident occurred on 29/11/07 at 1:50 p.m. By the offending vehicle bearing the registered number so, and the vehicle was insured with the National Insurance Company. And the said accident information report was investigated by SI Harishchandra Sharma, DW2, the certified copy of the FIR was also revealed that the accident took place on 29/11/07 at 1:50 p.m. my lord. That is the certified copy of the FIR.
Yes.
That is there, the certified copy of the FIR, that is 150.
Yes.
And insurance was there as per her statement. The accident took place at 9:15. At that time, there was no insurance.
Yes.
But the certified copy
No,
of the FIR.
but Mr. Bhattacharjee, the
Yes.
court have given the finding
Yes, then
on careful perusal of the exhibited
Yes.
documents
Yes.
and evidence of the
I'll go through my
witnesses.
enter judgment.
It appears
No, I am
that at the time of accident, the vehicle was not insured.
Yes.
And immediately after the accident, the owner of the vehicle, with the help of police, insured the vehicle with insurance company.
That's right. Yes, finding is there. The judgment which was given that insurance should pay to us. I think that is fully not discussed here on what ground. But I think, my lord, as per the Supreme Court judgment, I think they have given that you pay and you
So
cover.
that judgment.
That I'll give you. 2000. Citation, my lord, it is 2000 STPL. I want you to say 25 INS 951. Party whole National Insurance Company versus Suniti Devi. The same case, my lord, non-payment of the insurance premium. Your lordship will come to the paragraph.
1 second. Yes.
My lord, your lordship will come to the paragraph 5.
Yes.
In Navapara Supra, this court addressed very point interpreting the provision of the section 147(5), 149(1), and 146 of the Motor Vehicle Act 1988 in
This
relation
is
to.
different. The facts would be different.
No,
Here, the contract was because
thing,
of
my lord.
non-payment of premium, bouncing
They
of
have
checks.
also- Yes, madam. Here they have also not paid the premium for insuring the vehicle. That is why it was lapsed.
Is it?
Yes.
Not a question of lapse, Lordship. The policy was taken after the accident.
Not levy, but at the time
One
of,
32, the policy was also exhibited and we.
my lord, as per her version, at the time of accident, there was no policy. Why was no policy? Because premium
How
was
do
not
we
paid.
know? How do we know?
Yes.
That is not on record.
That is,
The evidence has not come, Mr.
Ye-
Bhattacharjee.
yes, my lord, that
See,
was-
Mr. Bhattacharjee, I am not saying that you are not entitled for compensation, but to fasten it on the insurance company who did not even come into existence on that date of the accident
I understand your lordship.
is perhaps not
My lord, I understand your lordship's query.
justifiable.
I understand your lordship's query.
I
but-
could have understood that the evidence shows that
My lord,
just hear me out. I could have understood if the insurance, if the owner had an insurance with this particular insurance company, it was going on, and because of lapse, there was some drawback, and then finally the accident happened the same night, it was renewed. That much I can understand.
My lord, from the.
But where is the evidence to show that this is because you see, today I have a car, I may have insurance with A. After the lapse of the insurance, next one I might open with B. It's not necessary that I'll continue with A only.
My lord, that is what my submission.
But where are these
Because
evidence?
when the policy is left, for what?
We
For
don't
non-payment
know.
of the.
Correct, but where are those evidence, Mr. Bhattacharjee?
That evidence, the insurance has to lead, my lord.
No.
Because they are the
hey.
defendant there.
Mr.
Claimant-
Bhattacharjee,
Claimant should not buy.
this is the court of record.
Yes.
I am considering the
My
appeal.
lord, they have to establish by their evidence that the policy was lapsed, they have not renewed. There's no such.
All right, I've taken noted of your
Yeah, that-
decision. Anything
that
else?
defense there.
Anything
So,
else?
your lordship will come now this year. What is the principle has been laid down?
All right, read.
Eventually, on the resident of the insurance contract, the word resident of the insurance contract, in relation to the eventually the residents of the insurance contract on the account of non-payment of the premium because of the bouncing of the check issued towards the premium. In that case, the check dated was dishonorary and insufficient fund, which respondent company cancelled the policy. Policy was cancelled and informed the vehicle owner as well as the RTO whether they have informed, my lord, to the owner that your policy has lapsed. They have never informed them, the owner or to RTO.
All right,
Okay,
noted,
then your lordship will come.
noted.
5-1. The court held that the contract of insurance stood rescinded due to the failure of consideration and intimation to the effect given to the person concerned. However, this court in exercise of the jurisdiction under Article 142 of the Constitution directed the insurance company to compensate the appellant and to recover the amount from the vehicle owner. 5-2. The subsequent judgment in the United Insurance Company Limited laid down the very principle that some statutory liability of the insurance to indemnify the third parties would insist unless the insurance policy was cancelled and intimation of such cancellation had reached the insured before the accident. That is absence in their case, madam.
Very well.
In this judgment also, this court.
I am again repeating myself and asking a very simple question to
Yeah.
you. Is there any evidence on record to show that this particular car was insured from this particular insurance company prior to the accident?
Yes, that is what.
Is I am only asking. If
Yes,
it's
yes.
yes, say yes.
Yes,
If it's
yes,
no, say no.
Yes, yes.
Is there anything on material
Yes,
to show?
Because that is why they have made party, they have come. to
I am
this
only asking, I'm not asking I'm looking for, you see, the question is not seeking a hypothetical answer. The question that I'm posing before you is whether yes or no. Yes
As
or
per the
no.
judgment-
And if yes, where is that?
As per the judgment, it is 130 and the copy was furnished to them
Okay.
before that.
Okay.
So 130 and the insurance policy was furnished to them. On the
Okay,
basis of that, this is judgment was passed.
Okay, fine.
Now, my lord, I am coming to paragraph 5 is over, my lord. From the facts on the record and more particularly in view of the decision of the court of Independent and United Insurance Company, it would be immediately seen that even at this, the court has understood the proposition that the cancellation of the insurance policy issued in favor of the third party for covering the third party risks because of bouncing of the check or premium is non-payment of the premium would in law absolve the insurance from the liability to pay compensation. And once the insurance has intimated the cancellation to the parties concerned in the final discretion, issued, the court thought it would fit to direct the insurance company to make payment of compensation to the claimant and thereafter permit to recover the same from the owner. This is in 2005, my lord. This is the latest one. It is given. And if your lordship also see our High Court judgment also, my lord. The Soran Singh case.
The citation?
But this is our High Court case, my lord. I have just what is by the Justice Kularabdip Chaudhary. Because he is based on the National Insurance Company, which is Soran Singh, others, which is the main crux of the case for the third party. Because this is a Supreme Court, which is in the Constitution bench, that whatever may be the reason, the insurance company, if it's not fault, will pay the to the third party and then he recover from the owner. That is the judgment of this court.
All right, noted.
Because if the insurance company would have walked into the notice before the tribunal, that intimated, it is a fact that they have the insurance company with them. That is why they are made party. They
Very
did
well.
not deny that they don't have the insurance. They
There,
face-
noted,
Right.
noted.
That's all, ma'am. That
Yes.
is my, I'm the third party, my lord.
Yes.
Your lordship.
Okay,
It is based on the,
all right.
Judgment of our High Court lordship, when there was no policy, the tribunal had directed to pay, then Honorable Judge said that since there was no policy, they have to recover it from the owner. Relevant part lordship is para 8.
Uh, This, the first judgment of the apex court, just give me the paragraph number,
551.
5.1. Just indicate the para number.
Lordship. 5, 5.1, 5.2 and 5.5.
And 5.5?
Right.
Okay. Very well.
Should I give another, my lord, for Rajasthan?
No, it's all right. I might deem, huh?
I think, my lord, this will be also helpful for your lordship. This is from the Rajasthan High Court, my lord. This pay and recover.
That's all right.
No,
If
based on
required,
the
I'll
Supreme
give
Court.
it.
So the,
Yes.
so that's
The Supreme Court decision is there.
Yes.
It's all right.
What?
Let me take your seat, counsel.
Yes, yes.
Heard Miss MS R.D. Majumdar, Learned Counsel, appearing for the petitioner within bracket insurance company. Also heard Mr. K. Bhattacharjee, right?
Yes.
Learned Counsel, appearing for
One and
the respondent number 1 and 2.
yes.
No,
What?
lordship,
Huh?
one is dead lordship,
Dead.
now 2 is dead.
For respondent number 2 within bracket claimant.
Yes.
You're the claimant, right? Who is the owner of the car? 3 and 4.
Yes, lordship. One is driver and one is owner.
No. Who are respondent number 3 and 4?
Owner and driver lordship.
And what about their appearance? Earlier, someone appeared.
I think the notice was served lordship, but they did not appear, no, Judge.
What happened to them? Nothing is.
Driver is Anirban Patnar
How come
and owner is Jayanta Bhatt.
this is owner just because everything is fastened on the insurance company? The owner has not come, but I'm only concerned if notice has been served or not, because I don't know what will be the outcome. The outcome may affect the owner.
Lordship, I have a note here, 6/6/22, respondent number order, Lordship. 3 and 4 notice duly served.
Where? Which order?
In
Office note?
22.
Huh?
Office note 31/122 and court order
One
6/6/20.
1 second, let me just refer to that then. Office order is dated
31/122.
31/22.
Yes. R1 addressee expired. R2 process server notice received by addressee. R3 and 4 notice duly served. Flag C.
Side আছে এইটো মই ইয়াত ভৰাই দিব খুজিছো I'll just indicate that but এইটো verify কৰি দিয়ক ইয়াত দেই মই পোৱা নাই
ঠিক।
আছে নাই নহলে
But কি হ'ল?
দিগদাৰ হ'ব কাৰণ
31/122 to serve.
and the office and the court's order also you said a date what was that date
6/6/2022.
6
6.
2020
2.
those orders are only not there 3/12/24 2/5/24 and then it's-
3/8/22.
no then suddenly it goes to 21/4/16 from 21/4/16 to 25/2024 what has happened that orders are not here
Oh, but then Lordship, by that order, we came to know that
where is it ordered
one
in
is-
Lamaprani on but where are those orders
It's highlighted.
where are those
This
orders
case was earlier dismissed for 2 times, my lord. Dismissed for default for non-appearance of the insurance. And it was sent back to the tribal court for giving the order. I think Justice,
no that's
Secure-
okay but I just
Sekia's
wanted
order
to
was
be
there.
huh?
Justice Sekia's order was there.
I want to be sure that they have been served.
Yes, I have my note here. 16.
Justice Sekia order.
Flag.
Otherwise, the entire draft is going on in my head right now. I want to give it, but I don't know once I start who is going to affect. Prima facie, it may affect the owner at this moment. Mr. Barua from the back is smiling.
Here. আৰু file আছে নেকি? আৰু সব
Record
আছে
of the side.
I brought you over. Did you?
কৰবাত
3
mix
আৰু
হৈ যাব পাৰে।
3 আৰু 4 whole nice now.
কিন্তু মোৰ ইয়াতেতো clearly লিখা আছে।
This is IO.
6/6/22 order to
3/8 also.
22. Not around.
These are the difficulties we face. You know, we are ready to dispose, we are ready to give judgments after hearing, but because of all these problems, we are not able to.
So I also. Judgment below.
31.
I also.
This order log.
Where did you find it?
It is in the IA.
Give, Anok, halke Anok. I to uliyai pila Anok.
8.
Main case to divide.
Because Lordship, it was dismissed. Restoration was there.
It appears that the office note dated 31/1/2022 in the I Civil 1625/2018 in the present McAppeal, comma, it is noted by the office that service report in respect of the respondent 3 within bracket owner. 3 is the owner. And respondent number 4 within bracket driver of the offending vehicle, owner of the offending vehicle, has been received back with process services remark within bracket notice was duly served. The said service report is kept is available in the file and marked as flag C. It further appears that this court, which is that order 3/8/22.
3/6. Same file.
3/6.
6/6/2020.
It further appears that in the said IA, this court on 3/8/2022 was further pleased to observe that that notice in respect of respondent numbers 3 and 4 has been duly served. However, despite notices having been duly served, as indicated above, today when the matter is called for hearing, there is no representation on behalf of the aforesaid respondent numbers 3 and 4. Stop. It pertinent that during the pendency of the case, the respondent number 1 expired, hence his name was struck off. Hence, the name of respondent number 1 was struck off from the cause title by order dated
3/8/2022.
3/8/20 by the aforesaid order dated 3/8/2022. By the said order, will you go back? Accordingly, the matter is taken up for final disposal today. The present appeal has been preferred. Rupa, yeah. The present appeal has been preferred under section 173 of the so and so Act against the judgment and award dated 21/5/2012, passed in MAC case number 84/2008 by the Member Motor Accident Claims Tribunal, Assam, awarding a compensation of 2,80,540 to the claimants for the death of the deceased. Stop. It is submitted. No, don't say that. The case of the appellant is that by way of the said judgment, the appellant, who is the insurance, who has insured the offending vehicle post accident on the same date, i.e. 29/11/2007, was fastened the liability of paying the compensation so awarded under the aforesaid judgment in appeal. Accordingly, the present appeal has been filed. MS so-and-so learned counsel appearing for the appellant submits that it is clearly established before the trial court that before the tribunal that Ms. Majumdar, I'm not familiar with these words, so you can feel free to Mr. Bhattacharya goes for the same with you. The tribunal, it is clearly established before the tribunal that the accident occurred on 29/11/2007 at about 1:50 p.m. However, the insurance of the offending vehicle was done with the appellant. What time? Where is that time?
Actually, our contention was that on 29/11/07, the accident had taken place at 9:15 a.m., which is mentioned in the judgment also, and the policy was taken at
9:15.
1:15
At 9:15
a.m.
and the policy was taken
on the same day
at about
1:32 p.m.
At 1:32 p.m. she accordingly submits that since there has been a clear finding recorded by the tribunal that at the time of accident, the vehicle was not insured, and immediately after the accident, the owner of the vehicle, with the help of police, insured the vehicle with the appellant insurance company, comma, by the insurance company, the judgment of the tribunal awarding directing the insurance company to pay the compensation awarded under the judgment is per se illegal and erroneous. In support of her aforesaid submission, she relies upon a decision of this court, of the coordinate bench of this court, passed in Oriental Insurance Company Limited versus Sahijuddin, alias Sahajuddin Ahmed, in McAppeal 190/2014. Date to dismiss, date to deliver that judgment of this coordinate bench of this court dated 13/12/2018. Per contra, Mr. So-and-so Bhattacharjee, learned counsel appearing for the claimant, vehemently opposing the submissions made by the learned counsel appearing for the insurance company, submits that the apex court has clearly indicated in the judgment in the case of National Insurance Company Limited versus Sunita Devi, reported in 2025 STPL 8338 SC, that the liability of an insurance company remains as long as the insurance policy is alive and is operational at the time of the accident, notwithstanding that for a brief moment, notwithstanding that due to lapse of the premium, there was a break in the insurance policy. He further relies upon the decision of the coordinate bench of this court in the case of United India Insurance Company Limited versus Sri Dayamanti Lahkar and others in McAppeal 110/2016. Date to Digiba, coordinate bench of this court dated 15/12/22, to buttress his argument that For which point you relied this judgment? How is this relevant? I think,
That last part, paragraph,
which paragraph?
last paragraph.
9.
Paragraph 8 and 9, my lord.
To
The apex court in
buttress,
the case of
to
Samana
buttress his
and-
argument that
It
even
is-
if a driver of an offending vehicle does not possess a valid driving license, the principle of pay and recover can be ordered.
Then 9 also.
He further submits that in the said decision of the in the said decision, the coordinate bench of this court has also considered has also held that the third party victim shall not be allowed to suffer any further, and therefore shall not be allowed to suffer, and therefore is to be compensated accordingly. Stop. I have given my prudent considerations to the arguments advanced by the learned counsels appearing for the parties, and have perused the materials available on record. I have also duly considered the case law cited at the bar. Having considered the aforesaid materials, the core issue involved in this appeal is whether the insurance company can be held to be liable for compensation for payment of compensation to the victim of an accident involving involving an offending vehicle when it is established by evidence before the tribunal that at the time of such accident, the vehicle was not insured. Stop. In other words, whether the subsequent insurance of an offending vehicle post the time of accident would fasten any liability upon the insurance company. Undoubtedly, a victim should not suffer. But at the same time, my conscience does not permit me to allow an insurance company to be fastened with liability of an accident at the time of which there was no insurance policy in operation. In the case of National Insurance Company Limited Supra, it appears that during the time of the lapse of the premium, an accident took place, and in the context of that case, as subsequently the vehicle was insured by the same insurance company, the apex court held that the said insurance company is liable to compensate the claimant in that case. However, there is no material whatsoever to indicate in the present case that the vehicle was insured with the appellant insurance company pre-time of accident. On the contrary, it is clearly evident from the judgment under appeal that at the time of accident, the vehicle was not insured, and immediately after the accident, the owner of the vehicle, with the help of police, insured the vehicle with the insurance company. That being so, the direction of the tribunal to get direction of the tribunal to the extent of directing the appellant insurance company to pay the compensation awarded under the judgment in appeal is erroneous and perverse. Now, but I don't think I need to clarify that because if this goes automatically,
No, in the judgment I have given lordships, in that at paragraph 9, the honorable court had made that way. In the result, the appeal stands allowed to the extent indicated above. The direction of
all
the
right, I will similar,
Yes.
because I thought I should indicate that.
Yes,
So that,
because they will be
yes,
pending.
yes. Tapsat Lekha.
Here it will be respondent number 3. He is the
As
owner.
such, no liability could have been fastened upon the appellant hetu upor koi dim moi, upon the appellant company in facts and circumstances tar pisot he baki khin lagai diba. Moi je kollu, buji pala. Etia lekhiba. In the result, this appeal stands allowed to the extent indicated above. The direction of the tribunal asking the appellant company to pay the compensation stands set aside. It is, however, clarified that the liability would now be wholly upon the respondent number 3, and the respondent number 2,
No,
petitioner number 2, right? Petitioner number 2 stroke claimant would be at liberty to proceed with the execution of the award against the said respondent. The impugned award stands modified to the extent indicated above. Return TCR. Sorry.
No, it's not. No question.
In this case also, I was the counsel.
Most of MSCT cases we see familiar faces.
Highly obliged, lordship.
Yes. Any pending IA is all disposed, huh? And I think one is pending still.
Pending?
Any pending IA?
No.
No, lordship. If there is, lordship can dismiss
If any IA is pending, then
dispose in view of this
All right.
judgment. Highly obliged.
Hello, item 12 in mine. So
you want another date.
I think Miller, please also.
All right.
So,
Okay,
can we-
arbitration appeal. When do you want it?
11.
11.
11 of May.
In item 12 as jointly prayed, relist on such and such date.
11.
Preferably on the top of the list. Preferably on the top of list of that day. I said preferably, I don't know what will be the
Yes.
position on that day. Yes. Yes, call 11.
May appeal by the claimant Miller for enhancement of compensation.
Enhancement.
Enhancement. Road traffic accident is dated 27/10/2012. Road traffic accident dated 27/10/2012. Claimant examined one witness, my lord. The insurance company and the owner driver examined 4 witnesses, my lord. The thrust of the evidence of the insurance company and the owner was, my lord, that the honored driver did not possess a valid driving license. The learned tribunal awarded a compensation of rupees 6,26,000 lordship.
This is a very rare moment,
Right.
where the other side is helping the. So, but this is good because at the end of the day, you all are officers of the court and you all assist one another. Very good. Yes.
6,36,500 with interest of 6% from the date of the filing of the evidence. Now, against it was also directed that the honor driver, the insurance company will pay and it will be recovered from the honor driver. Now, two appeals was preferred. One by the claimant for enhancement, one by the honor driver. The appeal of the honor driver was disposed of by this honorable court, directing the tribunal to take fresh evidence with respect to the driving license. In pursuance to that order, the tribunal again took evidence of the DTO Milord and came to the conclusion that on the day of the accident, they were possessing a valid driving license. So that part of the award Milord that will be recovered from the honor driver, it goes Milord. And it has attained finality also Milord because none of the parties have challenged that order till date Milord. So the only question that remains before this honorable court Milord is the enhancement of compensation by the claimant. This is the
How much has been given?
6,36,500 with 6% interest from the date of the filing of the evidence on affidavit.
What is the enhancement that you're seeking?
Milord, we are praying that the income was taken as 4,500, Milord. We are claiming it 15,000 approximately, Milord, on the basis of the income tax
No,
return.
4,000 was what was taken.
4,500 was taken, Milord.
And that was taken on what basis?
That was taken on the basis, Milord, that we could not prove our salary and income, Milord.
You could not prove.
We could not prove, Milord. That lordship can find out.
Now, on what basis are you saying it's 15,000?
Milord, there are two, Milord. One is, Milord, the income tax return, Milord. That is a statutory document that was not considered by the tribunals. Two, Milord, there are other documents which we have furnished, like
Not factual.
factual situation.
That aspect can go in,
Yes, Milord.
be gone into in 173.
Lordship, yes, Milord. The first appeal, Milord. Lordship can.
Yes.
Now, if your lordship, Milord, we have furnished a paper book, Milord. And
Paper book, this, sir?
yes, other documents are filed into form. Other documents, paper book. Oh, yes, other documents. The road traffic accident, the death, the age of the deceased are not in dispute, Milord. So we are not going on to that aspect of the matter. Only in
Ultimately, it's reappreciation of evidence that you want.
lordship, to the extent of
Because according to the trial court, the proof is about 4,000. On that basis, they've held 4,000, right? But you are saying no, it should have been 15,000.
15,000,
Odd.
approximately, Milord.
Odd. Yes.
Lordship can take up, Milord. Page number 20. Page number 25 onwards, Milord. Lordship has page 25.
One second. 20?
25, Milord. I was working as an electrician, Milord, in Sanjeevani Hospital, Lordship.
Yes.
Now, this is the salary.
You're working as
Working as electrician, Milord.
electrician.
Electrician. Page 20. So, Lordship, sorry, page
You're-
60. Page 60 of the paper book, Lordship.
Huh?
Page 60 of the paper book.
60.
60, Milord.
Yes.
This is to certify, this is a certificate from the Sanjeevani Hospital. This is to certify that late Karan Singh was working in our hospital since 1/4/2008 as an electrician.
This was
It-
exhibit 5.
This is exhibit 5, Milord.
Yes.
Now,
Net payable 5299.
Lordship,
Is that the salary?
this is the salary, Lordship.
Yes.
Now, Lordship can see the page 61.
Yes,
This is a certificate again from the Sanjeevani Hospital. Page 62 is the PAN card,
yes,
and page 63 is the ITR refund, my lord.
yes. Yes,
It was received on 13/1/2011, last line. Here my income, yearly income is shown as 145,240.
yes,
Now page 64, it was of, my lord, assessment year is of page
yes.
64, again my income tax return, my lord. My gross
Oh,
total,
your proof would be page 60.
lord, 60 and
60 is 5,299.
no, that is my income from salary, my lord. My income tax reflects my total income, my lord.
Here this is motor vehicle
Motor.
accident. Yes. So what was the other source of income?
My lord, I was, that I have come to you, my lord.
No, but I want to just tell me what is
Milord,
the other source of
I
income?
was working as an electrician privately also. There are certificates to that effect also in this claim petition. that
Where
is
are those certificates?
That's it.
Before
That's
we
it.
go to the income tax return,
Page
because
70
you show me that.
Page 77.
Because you see, the foundation
I
proof has to be there.
I
Then only I can appreciate your income tax return. Otherwise, how do I know from where these money has come?
That's it. Page 77, now.
Page?
77. This is to certify the currency and so and so and the so and so.
77.
77 also. The biology construction that I worked in 2 projects, not has given a certificate.
Yes.
This is certify new like currency from so and so, this is so and so. This is for more than since 2009. I certify that he worked with us in our various projects for application 2 years on the following projects. So my income was
Worked with us as an electrician in our various projects for approximately 2 years on the following projects. Now, how much did you get from there?
No, I as an electrician I worked in different projects in law.
No, but how much did you get from all this?
But that I cannot,
No, those have to be brought.
No, once the claimant deceased died, my lord, that information was with the deceased. We cannot now assert it with certainty. And what in such circumstances, what the constitutional court has held, my lord, that income tax document has to be considered, my lord. One that is important. We'll come to that, lordship.
Now, the income tax shows what?
15,000, my lord.
Where should
sorry,
that
lordship.
part?
1,50,800 to 60, my lord. Page
Where-
64.
Where is that figure?
150 to 60, my lord, to divided by 12.
Is the gross total income.
Gross total income will be divided by 12, my lord.
1,5,8
divided by 12.
So 15,000.
Not 15 or 12,000, something it becomes.
How much does it become?
Let's say 158, 260, 158, 260 divided by 12.
So, but how do we know these calculations? I'm not
13,000.
an income tax expert.
No, that's
Where are those
Yes,
evidence?
13,180.
Where are those evidence?
That's it. In MSc cases, my lord, there are 3 ways to prove one.
Yes, but something has to
No.
come now. You see, this 64 says 158,260. Now that is indicating what? Mr. Burma, I'm sure because I'm not very much acquainted
I
in these kind of appeals much, but nonetheless,
Mhm.
there has to be some basis
Some basis.
to say that you are entitled for 15,000, right? Now,
13,000.
whatever, huh?
13,000 is coming, 13,000 something.
Now, how do we know how this will go to 13,000? The courts are not income tax experts. And let me tell you, I am very bad in maths. That is one subject I used to run away from. I don't know about you, but I'm very bad in calculations. Mr. Datto, I can see he's also smiling. I don't know whether he's better than me or he's good. The worst. So something has to come, no? You see, something too has to be there.
That is my
Like say, for example, this certificate is clear. 5299. It's very clear. If there was a certificate showing that yes, you get this much Definitely.
Yes. my lord.
But this income
No,
tax,
that is the.
now no, you should have brought in evidence where in your evidence in chief is given.
Yes, Lord.
So there have you said that all this comes to this much?
My lord, I said that I was working as an electrician.
Working as a, that is okay, but how much you used to get? Where are the bases to know? Even if we have to imagine,
Lordship.
even if we have to go by those standards laid down in that Varma, na?
Sarla Burma, Pranay Sethi.
Correct.
But these are case law that determines the formula, Lordship.
Correct. That's
So-
what, that is what I'm saying. Ultimately, to give you, we'll have to fall back on the formula.
Here, first thing is that how Lordship will determine my income, Lord. That is the first question, Lordship. So to determine the income of any person in a motor vehicle act, Lord, the first thing the Lordship has to see, Lord,
How much? Huh?
the first the Lordship has to see, Lord, is whether I am able to prove by mode of income. That suppose I am working as an advocate, Lord. Then Lordship can presume that okay, an advocate earned at least 30 to 40,000 rupees. That presumption
So
is
that is
permissible,
okay,
Lord.
but now you see,
That permission.
now you see, Mr. Barua, the problem is you have only given one income tax
Not true.
and you have, sorry,
Now,
and you have given one certificate
not true.
of a
But to
of a construction company
company.
saying that for 2 years he was
Okay.
working as an electrician.
Okay.
That's all.
Now, not,
That's all.
that's
Nothing else.
no one.
Nothing else.
One.
Now an electrician in these projects, now we don't know
No.
whether he was the head electrician, whether he was a helper electrician, what kind of money was he getting. How can we assume? Because if he was the main electrician for this whole project,
Look.
his earning would be different.
Look.
If he was merely going there as an electrician
Look.
to just hold the wires while the electrician is doing the fixing, then it would be different. Where are those?
Now, yeah,
Because apart from your page 60 document, which is very clear, if today you would have said it, in the evidence that yes, I'm an advocate, I'm going to the trial court, I've been doing this, yes, it will be easy. One can understand. But where are those
but
pleadings? Where are those evidence that you have been constantly doing this work in those constructions company? From where do we start assuming?
two aspects.
How do we connect
One
them?
is Lordship can understand that Sanjeevani Hospital has certified that I am an electrician, my lord.
Electrician is okay.
Electrician is
He
okay,
doesn't
lord.
certify. You see, you are electrician.
To
We
that-
know.
to that
We
extent-
don't need that certificate
No.
from that hospital.
Lordship.
By
That
now, you have
extent-
proved that you are an
Lordship,
electrician. Now the question is, what kind of work you did in Sanjeevani Hospital?
Lordship has also seen that certificate from the Sanjeevani Hospital.
That you were involved in electrical work from some project. But what was the nature of that electrical work?
My lord, there are constitutional court, Supreme Court, by Katina of judgment which says. my lord,
Correct. Those are contextual. Yes.
No,
Yes. Yes.
when the
Yes.
claimant comes up with an income tax return, my lord, that has to be treated as conclusive proof.
No, that's okay. But there has to be something to link with it.
No, even if there is none, my lord.
Show me that decision.
Income tax return.
Because if that be so, yes, you have shown.
Yes, lord.
Your income tax is there, showing that you get about 13,000. But if that can be
That's-
solely,
Solely, my lord.
let's see
Even
in
for
what
the-
context.
In what context?
Because you see, ultimately the context cannot be forgotten.
Lord, lord.
Decisions of the apex court are only contextual. Principles is based on that facts.
Page 4, my lord, of this judgment, my lord, first judgment, Kalpana Raj, my lord, 2015 Supreme.
Which one? Kalpana.
Kalpana Raj, my lord, page 4, paragraph 8.
Page 4, paragraph 8.
8, my lord. May I read, my lord?
Yes.
It is pertinent to note that the only
Yeah, well.
available documentary evidence on record of the monthly income of the deceased is the income tax return filed by him with the income tax department. The High Court was correct therefore to determine the monthly income on the basis of the income tax return. However, the High Court erred in asserting the net income of the deceased as the amount to be taken into consideration for calculating the compensation in the light of the principal later. The gross income has to be taken into consideration. But so far, my lord, as determination of income, my lord, that is prima sufficient proof, my lord. The second judgment of.
No, no, that is only when only that is available.
It is
Here is
particular-
not a
the
case.
Only available document.
Correct, but
Lordship.
here is not that case.
Lordship.
The only available document is not the
Yeah.
income tax.
Lordship.
The document, because you are a regular employee,
Lordship.
you are not
That
only,
judgment is also.
you see, Mr. Barwa, you are
Lal.
not some, huh?
Lal, Lordship.
Oh, sorry. I don't know why I've been referring to as Barwa today. Mr. Lal, right?
Lal.
Yes. Sorry. Mr. Lal, those decisions and in the facts of your case, you are not only the electrician of Sanjeevani.
Lordship.
It is not that for 2 years you've only worked
No.
there. You have only shown 2 years. Now we don't know if again you will get some work like this or not. You see, there are a lot of ifs and buts. This is only one project you have shown.
Lordship.
You may not get any more projects. We don't know how you work there.
Yes, Lordship, but on the.
So many factors will come
But
because you are a regular, otherwise you are a regular employee of where?
Yes, Lord. Sanjeevani Hospital.
No. That you are a
Basic
regular, this 5,000 is what?
Sanjeevani Hospital, my lord, I am a regular.
Was working in our hospital since so and so as an electrician. So this is your regular work.
Regular work.
And for this, his salary structure was this. However, apart from this,
I have.
you had done two
Different
project,
electricity
not
work.
different projects. For 2 years you have done. That
2 years.
certificate says.
Certificate is
For,
said, reading says that, my lord, I have worked in a different.
I certify worked with us as an electrician in our various projects for approximately 2 years on the following projects. For various projects for approximately 2 years. And what are the two various projects is already given 2 projects.
No, Lordship then has to see my evidence on affidavit, my lord. That is that paragraph, page 38, my lord.
Yes, where?
Page 38, Lordship.
That's what I'm trying to correlate.
Lord.
So yes, affidavit at page 38.
Yes, Lord.
Yes,
Para 7 and 8, my lord.
yes.
That I state that the deceased was a 22-year-old man. The whole family was dependent upon the deceased. The deceased supported the monthly household expenses of the whole family, as well as the educational expenses of the brothers and sisters. It may be mentioned here that the father of the deceased is not physically well, and as such is unable to earn livelihood for the family. That I state that my son was a hardworking young man. He started his career at a very early stage of his life as an electrician. Therefore, he took employment in Sanjeevani Hospital situated in Maligaon, Guwahati. In the aforesaid hospital, the deceased was getting a salary of so and so per month. The work of the deceased involved repair maintenance of the electrical equipment. There was no duty hour. Deceased was required to report as and when the electric defect was noticed. As such, the deceased was free to utilize his time off to and do electrical work in different fields. The deceased used his free time to do business in electrical work, and a substantial amount of money was earned by the deceased by doing business. The deceased has taken subcontract as electrician in different buildings. So this fact has not been disputed in cross-examination. If your lordship takes up the cross-examination part, my lord, that is at page 78. And there is a catena of judgment of the apex court, my lord, that once we come up with the income tax return, that has to be treated as final proof of income, my lord. From Justice Chandrachud to all, from 2012 onward, this trend has come.
So in a way, you are trying to say that apart from that 5,000, there are proof saying that your income was not limited to 5,000,
5,000,
but much more.
Much more higher.
So
And for this-
ultimately, the court one may not make it 15,000 or 13,000 in overall, but compared to that, the income now that has been taken is less.
very less.
So
Lordship,
it
let
should
us-
be
let
increased
us-
proportionately.
Let us come to the facts. my lord.
I think this is what you're saying, right?
I am saying my income was, my lord, that the income tax return should be taken into consideration, my lord.
This matter cannot be sent to the mediation.
No, no.
Why?
2012 accident, my lord.
Yes, that is more the reason
Cannot
that
be,
it can
and
be, because
because-
if they can
Because in
come up
various-
with
No, my lord.
something more,
The difficulty with the insurance companies, my lord, they don't pay interest, my lord, in mediation. And that is, my lord, and we have lost substantial amount, my lord, of time also, my lord, and Lordship may kindly see just 2-3 facts more. my lord.
yes, no, you complete this evidence part.
Lordship. Now,
Hmm.
Lordship can take up page number 71. my
No,
lord.
no, just finish this page 38.
Okay.
Let us finish the whole evidence.
Lordship.
Let's read. The DCU is used, then thereafter. There are many other
Paragraph
projects.
9, my lord.
Yes.
That I state that there are many other projects undertaken by the deceased. However, either there was no written agreement or the same could not be traced and hence are not being produced before this honorable court. I have, however, furnished one certificate from a builder who came after the death of my son to console me. I said that this was involved in different business. I do not possess any documentary evidence to prove the same. That I state that the business of the deceased was flourishing, leaps and bounds, and as such, to learn new technology as well as for keeping records of ongoing work, the deceased purchased a laptop. We have annexed that document, my lord. And thereafter, the business of this was flourishing. The deceased to travel from one side to another, purchase a motorbike. That document also we have annexed, my lord. That I state that after the accident, this is for his good health, so and so accident. Paragraph 13, that I said my son was the only earning member of our family. I further state that 7 except his earning. I or any member of our family had no earning of our own. After his death, we are virtually without any support. Now, Lordship can see cross-examination part, my lord. These factions were not disputed, my lord, by them, my lord. Page 78 is the cross-examination.
Yes.
I have 4 children. My husband was 2 to 3 years older than me. I cannot say why I have not mentioned the age of my children. Claimant number 224 in the claim petition. I have not drawn my claimant children to this tribunal, though I have stated in paragraph 2 of my affidavit of examination in chief that claimant number 224 authorized me to file and conduct this case. I have not submitted any authorization letter before the tribunal today. I have not seen the accident. It is not a fact that an unknown vehicle killed my deceased son and the vehicle registration number so and so were involved in the accident. My deceased.
Just one sec, Mr. Lal. Rupak.
Number 2 about it really
Yes.
Last paragraph. My deceased son appeared in the HSLC examination. I have not called the MVI to prove the Exhibit 2-3 report. I have not brought the administrative officer of the Sanjeevani Hospital to prove Exhibit 1 certificate. I have not brought the person who has issued Exhibit 12, 14 and 15. 12 is the identity card of the Sanjeevani Hospital. 14 is the Star Health Insurance Bureau and certificate from the Balaji Construction 15 Bureau. To prove the same, it is not a fact that I am not entitled to receive any compensation from the opposite party number 2 of the insurance company. So in cross-examination, my lord, the income tax documents were not at all disputed also. Now, if your lordship again takes up the, my lord, the case law that we have furnished, my lord. Very short, only one paragraph judgment are there.
Yes, yes.
The second judgment is a Bondita Datta of our High Court, my lord. Paragraph.
So this first one, Kalpana Raj, is on the income tax. Income tax return.
Yes, about with regard to income tax. These are also of income tax return, my lord.
Yes.
Bondita Datta case, my lord.
Yes.
Second page, page 61, my lord, paragraph 4.
Page?
Page 61, my lord, paragraph 4. In order to buttress this point, Mr. Chaudhary has relied upon.
One second, you're too fast. Wait, let me open the page.
I'm sorry.
Paragraph?
Paragraph 4.
4.
4.
Yes.
In order to buttress his
You
point.
see, you've been waiting here since 10:30 to do your matter. I can understand that anxiety and all that energy that you had kept inside you, but this court has been dictating judgments, hearing matters in 10:30. So by now,
I can
the
understand.
court automatically will slow down a bit. Yes.
Paragraph 4, Lord. In order to buttress his point, Mr. Chaudhary has relied upon a decision of the Supreme Court in Anjali versus another versus so and so, AIR 2023 Supreme Court. The quotation is this, the tribunal and the High Court both committed grave error while estimating the deceased income by disregarding the income tax return of the deceased. The appellant has
So here also the income tax return.
that has been taken into account. Yeah.
So this is also on the same point.
Same point. Now, Lordship can see.
So this Malarvisi is the different case, no? This says it's reaffirmed that the income tax return is a statutory document on which reliance be placed.
Lordship. This case, my lord, it says this case, that is the fourth judgment, my lord, that we have quoted. Malarvisi case, my lord. Now, Lordship can take up the Indori Devi case, my lord. United in 2018 S 7 Supreme Court SSC 715. Now, in this case, there are two
See,
certificates.
now here it was easy because it says income 30,000. But here, how do we take that? When we go by that, it will become 13,000.
13,000. And Lordship, now the difference between the income, salary income, my lord, and the total income, my lord, that was dealt with by the United Indori Devi case, my lord, 2018, 7 SSC 715, the fourth judgment. In this case also, the salary was different, the income tax document was different. The Supreme Court said, no, you should consider the income tax document.
Which one? Which is the next?
Next one, my lord, next one is Nidhi Bhargav.
No,
Thereafter, my lord.
where you said salary was different? This one?
Indori Devi, my lord, 2018, 7 SSC, my lord.
Indori?
Indori Devi.
Yes.
United in the case, my lord.
Yes.
Paragraph
This is that Malar BZ is also given.
also given.
Statutory. But give the citations for the benefit of the other side. Just give the citations because
already
we are referring
better
them by names.
Yes, my lord.
I'm surprised that he's not asked. I think he knows all these case laws.
No, it was already given on the previous occasion. That citation was already matter was heard on the.
You have the citations?
It provided us now also. Your Honor.
Is provided? Okay. Yes.
Indori Devi case, Lordship.
Yes, I have Indori.
Yes, Lordship. Page 2, paragraph 4, my lord. The issue in this case, Lordship has been paragraph 4. Revolves on the income of the deceased. On behalf of the account section of the employer of the deceased, which was reported, deceased was getting rupees 8848 as gross monthly salary. The deponent proved the salary certificate. The amount of salary was not questioned. The tribunal passed the award on the basis of the salary he was receiving, that is so and so. The tribunal did not take into account the fact that the income tax return of the deceased shows an income of so and so per annum for the assessment year so and so for assessment year so and so. The tribunal held that the claimant had not led any evidence to explain the contradiction between the two figures of income emerging from the evidence of the employer of the deceased and the income tax record, and passed the award relying on the certificate issued by the employer of the deceased. In a revision carried to the High Court by the insurance company.
Okay, I've read it.
Okay. So 7.
Yes, I've read it. I have understood para 7 and 8. Yes. In the next case?
No, the next case.
That's all, no?
Nidhi Bhargav case, my lord, is also.
Huh?
Nidhi Bhargava.
Yes. What is
It
that?
is
And
para
what is
13.
Sangeeta Arya?
Sangeeta Arya will be paragraph 13, my lord.
Paragraph 13.
13, my lord.
On what point?
On income tax, my lord, same.
You don't need so many cases.
Okay.
You want the judgment to do, or you want it to be reserved? Why are you giving me so many judgments?
And
Yes.
that last case, 2022, my lord, that Malarjeev case, my lord.
Huh? That I have seen. That is that the extracted in the judgment of this court.
This court.
Yes. You see, one good judgment on the point is good enough. You multiplying them will only indicate you have a weak case. Huh? You don't what is required is the judgment, not quantity.
Not the
5 judgments will not make your case better.
only one thing, Sangeeta Arya case, photocopy of the income tax document was submitted.
Which one? Which one?
Sangeeta Arya case. my lord.
That you tell me. Wherever there is a difference, you tell me. Here, photocopy of what was given?
Para 13, lord. you can-
13. Photocopy of what?
The income tax return was given.
That was taken.
That was taken. A photocopy of the original RTR for a so and so was filed before the court, bearing the rubber stamp of the income tax
Sufficient.
disbursement. Sufficient. my lord.
Okay. Let me hear the other side.
That's it. Now, there are two other points. my lord.
Ah.
One is, my lord, Latif has seen the cross-examination part. my lord.
Yes.
The fact that has not been disputed in cross-examination cannot come, my lord. What is
Yes.
the relying on two judgment of this court, my lord? One is of.
You don't need a judgment for that. Mr. Lal, take your seat. I'll come back to in reply.
That's where interest part is also there, my lord.
What is interest?
My lord, so far as the interest is concerned, my lord, we are praying that it should be from the date of the filing of the claim petition, my lord. And second, my lord, it should be 9% or 12% as in the.
Where?
My lord, in different acts, my lord. If you lord should take only one judgment for that interest part, my lord,
Here, how much is given?
6%, my lord.
AC to dear. 6%.
6%. Just to go there.
আমার কপি হলো।
এটা কেটে পারি স্যার this bench, however, will have to rise 15 minutes before 4. So I think you can finish by then. No? Because there's another bench I'll have to go and join at DB
But just one
Yes,
paragraph. we will
at
go
4.
for.
I don't think, Mr. Datta, I don't think going by the fact that now in some time I'll have to, so you can ask the court master in case of joint, both councils are there, agreeable dates. So if you want that accommodation can be given, but please approach the court master. Huh? And in any case, if any interim has to be extended, just tell. Come on. Yes.
The first judgment only we will refer Lata Agarwal case Milord, for the interest Milord.
Huh?
Lata Agarwal case Milord, so far as the interest is concerned.
Lata Agarwal, it's part of this.
That's the part of it.
Huh?
Yes, Milord. We
Oh,
have furnished now.
Belekiri, sir.
Yeah. Huh? It was it.
Yes. Sorry,
Regarding rate of interest?
you want to say something?
Yes, yes.
Wait, I am to hear you. Let him finish. Are you finished or not?
5 more minutes.
Yes.
Paragraph 17, Milord.
Yes.
Grant of interest from, we can start from paragraph 60, Milord, sub-para 60, Milord.
Hmm?
Sub-para 60, Milord. Page 7, that's paragraph 17.
Yes.
Sub-para 60.
Yes.
The rate of interest provided and granted under different act is as under. Under 4.3 of the Workmen Compensation Act 1920 provide a payment of interest of 12% per annum or such high rate.
16 you are reading.
60, Milord, paragraph 17.
Oh,
And sub-para is 17. Milord.
yes.
Sub-para
yes.
is 60, Milord.
I've got now. Yes.
Sub-para 60. Milord.
Yes.
The rate of interest provided and granted under different act is as under. Section 483 of the Workmen Compensation Act 19 provides for payment of compensation at the rate of 12% per annum or at such high rate not exceeding the maximum of the lending rate of the scheduled bank for the delayed payment of compensation. The Consumer Protection Act, even though provides no provision for grant of interest, this court has granted interest by invoking Section 3 of the Interest Act and Section 34 and awarded 12 to 18% on delayed payment. The Land Acquisition Act provides for an interest for delayed payment at 9% for the first year and 15% for the rest of the year. The Arbitration and Conciliation Act provides 18% per annum and 31 under Section 31(7). In the case of so-and-so New India Company, Nationalized Bank are granting 9% fixed deposits on interest. Now, Milord, my question is why this type step-motherly treatment, Milord, with MSCT Act, Milord? Lordship has seen 12% is the minimum that are being granted. We are the victims of a road traffic accident, Milord. The payment
12% is the minimum where?
In the different act that has been quoted by this judgment, Milord, the 12%
And in the MACT cases, is there a rate given?
not given, Milord. The
discretion.
discretion. Discretion of the tribe.
The judge has exercised his discretion. What is wrong in it?
That the discretion has to be.
I am with you as far as the enhancement of the ITR is concerned, subject to what falls from the other side. But as for the interest is concerned, where is the question of enhancing it? They've already given 9% is not that lower.
6%, Milord.
6 is given. 6 is not that low.
Now, Lordship can say, Milord. Take up the next
Anyway, I'll come back to that on. Yes, you want to show something on the rate?
Rate of interest, regarding rate of interest, Supreme Court is clear.
Very well. Show me that.
6% interest.
Which para? This is involving motor vehicles.
Motor vehicles.
Which para? Your name, please. KK? Bhatto. Yes, Mr. Bhatto. Which paragraph?
Lordship, para number 12. The aforesaid convention shall carry interest at the rate of 6% per annum from the date of filing of the claim petition till realized.
Paragraph 12.
Last part, Lordship. In view of aforesaid evidence laid by the claimant, we propose to assess the compensation.
Sorry, I'm not being able to find. Paragraph. Oh, okay. Yes, sorry, yes. If the tribunal concludes, para 12 is, how does the para 12 start? I think the paragraphs are not same. How does it read para 12 from your?
The aforesaid compensation shall carry interest at the rate.
No, where is it?
Paragraph, in view of the aforesaid evidence laid by.
No. This is
This
that
is-
TJ Parmeshwarappa,
Yes.
paragraph 12.
Yeah, okay.
Oh, that is part of para 13. There is a 19 paragraph. In that 19 paragraph, the principles that they have discussed, there they have brought in 9. I don't know from where. Here you are saying 12 in view of the aforesaid evidence. Correct?
Yes.
Now read.
In view of the aforesaid evidence laid by the claimant, we propose to reassess the compensation as under. Then hereafter, the aforesaid compensation shall carry interest at the rate of 6% per annum from the date of filing of the claim petition till realized.
Yes. So,
Well, as per my view, regarding rate of interest, 6% is, let's say, the learned tribunal is correctly.
if you see what I can appreciate if you say that 6% granting of 6% is not low, because even in similar situation, the apex code also grants 6%. That is understood. But by saying that, I thought what you said is that this is a standard set it. There is no finding as 6% should be the only one. If one can also give 9%, one can give 10%, but that is the discretion of the court. There is no fix.
Nowadays, a rate of interest for the fixed deposit amount is also not 6%.
Is also 6. Deposits for FDs.
Yeah.
Okay, fine.
Regarding income.
Yes.
Income of the deceased.
Yes.
So it was not proved. He was a salaried person as per the evidence of record. He was a salaried person, and the salary was not proved. It was disputed. But no person was examined to prove the salary certificate.
Okay.
Even the ITI return also not proved.
Salary. Okay.
Salary was also not proved. ITI return was also not proved.
Okay. But that on the basis of that salary, 5,000 has been given.
Yes.
And you are not challenging that appeal. You have not challenged that part.
Regarding salary cut, we disputed, let's say, regarding in the.
No. Have you filed an appeal, cross appeal saying ki, no, that salary should not have been accepted?
Narendra Modi did not consider the salary also.
5,000 they have given.
4,500.
4,500 was considered. Salary was also not considered.
Not considered.
Not considered. That is why not, since no person was examined to prove the salary certificate.
Where do I find all that? Page.
Let's see, page 101, let's see, para number 19. 101.
Yes.
Now the moot point to be answered as to what would be the quantum of compensation. The age of the deceased was stated as 22 years and he was working as electrician in Sanjeevani Hospital, but the authority of the Sanjeevani Hospital is not before the tribunal to prove the salary certificate. But the fact remains clear that he is aged about 22 years and he could earn a sum of rupees 4,500 per month, which can be enhanced to 50% and would come to rupees 6,750. Admittedly, he was a bachelor, so 50% of his income is deducted for his personal living expenditure. He left his mother and 3 sisters and 1 brother. However, their age are not known to this tribunal. They have also not submitted their photographs in the claim. Age of the mother is about 46 years. On considering all this aspect, the following convention has been assessed. Total loss of dependency would come to rupees 3,375 into 12 into 13. Multiplier is adopted for the age of the mother equal to 5,26,500. And loss of estate, loss of life affection, funeral expenses, any other expenses. So Lordship, in this case, salary was not proved. And regarding ITR also, it was not shown whether it was come from the salary or for the other business. It was not segregated, Lordship, in the ITR return. also.
What do you have to say to the decision cited showing that that only even if the ITR is the sole proof, that can be the basis for taking that as the basis for computation of the income?
Not brought such kind of decision, but when
Huh?
there is,
Huh?
I have not brought such type of decision.
The decisions Mr. Lal has given,
But then,
they
in
are
itself,
very clear.
when there is
That
no-
it says it is statutory. The ITR is a statutory document. And if the statutory document is exhibited, whatever is there is going to be taken. This is what the Supreme Court decision says. Even a photocopy of the ITR is accepted.
etc. But in this case, Lordship, there was, as per his evidence on record, he was the salaried person.
Correct. No.
But
As per his
But in the-
evidence, no, Mr.
in
Mr.
the
Counsel,
IT
Mr. Bhatta, I was also taking that, I was also thinking that his evidence was only to that, but you see, his evidence is clear that yes, he was salaried, but in addition to the salary, because he has a lot of extra time, he used to do electrical work for other companies and projects. And in order to show, one certificate also has been given. But of course, these electricians will not be getting any formal agreement for doing work. So it is difficult. And at the end of the day, he brings a statutory document. And that is on record. Supreme Court says that no, that alone is sufficient. You need not prove it by bringing all foundational facts. If the statutory document is there showing this is the income coming, then that can be the sole basis. This is the decision of the Supreme Court. I am not saying this.
he is a student of HSS.
I am not saying this. So that is why I am saying to the decision cited at the bar. How do you distinguish? I am asking you.
In that case, Lordship, the salary was proved. In that
No,
case.
no. In few of them, there was nothing. It says only ITR. And in one decision, he has further given where there was salary given, it was less. But the ITR was more. Then the court says, no, the High Court and the tribunal went wrong by only relying on the salary. Because the ITR shows something more. His income was much more than his salary. That is why I was asking if those decisions you have seen or not. Because he was citing.
But in the
You-
ITR, but in the
Mr.
ITR
Counsel, I am asking you a legal question now.
But in the ITR return, there must be distinguished that whether this was from the salary or the
That
other
is
income.
not required. It is showing his income, gross income. You see, the Supreme Court decisions are there. If they are not there, of course. I was also thinking in the same line that you are saying. But now I get it. These are beneficial legislation. That is there. And it's a statutory document. If that was not there, different. If he would have just simply said, oh, I do a lot of electrical work, how do we now know how much he will get? That is totally different. Absolutely no basis then. But here the ITR is there, and coupled with the fact that his father have given evidence that yes, apart from his regular work for which he gets a salary of this amount, he does so and so. And to prove all that, the ITR is given, which is a statutory document which have been accepted by the apex court, even if that is the only document to show that this is what he earns in a given financial year. That is there. That is there. Even today, let's assume that yes, you are right, that he could not prove his salary. He couldn't prove anything. But what he has proved is a statutory ITR showing that he earns this much. Have I understood you correctly, Mr. Lal?
That's my point.
We can have it tomorrow. You have a look at it. 5 minutes, not more than that. Only on this.
There are two more points were there in law.
Mr. Lal, you see interest you're not getting.
Lordship.
This,
No,
I am inclined to.
interest, no, I'm not saying what interest.
What more 2 points?
Lordship.
And then I'm posting it after 2 months. We will hear it.
Lordship, just one more point.
When I'm ready to give you the judgment, you are insisting on some other points and points.
Calculation is wrong.
Huh?
They have calculated the age of the mother to
No, I'm not getting into this. This was a
Multiple-
case of enhancement.
multiplicand is wrong. Pranay Sethi judgment said the age of the deceased has to be considered. The tribunal considered the age of the mother.
After your argument, you're bringing one by one. You first only simply say that enhancement for this. Now you are saying the multiplier method is wrong.
Settle will have law, there is nothing on that law, Because
Heard,
Okay.
Mr.
Regarding your lordship ITR, see, I think that may be considered. lordship.
That's right. That's right. I think so.
It may be finished. lordship.
I'll give the judgment tomorrow at 10:30. Right now, there'll be no time. For judgment, I am not hearing anyone any further.
1 point.
No point.
Lordship, multiplication cannot be the mother.
You want judgment at 10:30 or you want Tuesday for further hearing? Or Thursday, next Thursday?
Lordship, just 1 point first, dear Lord. One issue, and that's why Leonard Friend would agree that Pranay Sethi case.
Heard Mr. Elal,
Elal.
learned counsel appearing for the petitioner. Also heard Mr. KK
KK Bhatt.
Bhatta, learned counsel appearing for the insurance company. Arguments having been concluded, the matter is, the arguments more or less have been, the appellant has concluded his argument. So has the insurance. You are for the insurance? So has the learned counsel appearing for the insurance company. Relist on Tuesday so and so for further hearing.
Millerpur.
এইটা কেস বেলেগকে থোৱাচোন এইকেইটা just হেৰি কৰি দিয়া. The case which you gave is the T. Parameshwar Pana. That multiplier point is taken as a ground in the appeal.
And it is settled law after the constitutional bench judgment. While Leonard Friend will also not object to that. Multiplier will not. Part hurt matter.